You're rocking with the DJ that keeps the hits coming.
Wait up, run it up, run it up. I'm in the kitchen, cooking up something new, yeah. She's singing along to our favorite tune, wow. Enjoying the breeze from Toronto. They admire my watch.
You're rocking with the best.
Like you had something to share. What's up? I thought so. Okay. I'm back in this game, now you're waiting on the bench. I thought so. Okay. He's back in this place like he had left something behind. Celebration for tonight. I'm feeling ready for the night. Confidence high, we making moments to remember, and leaving behind the worries, moving forward, favor. Got a plan but no rush, just taking it slower and better. Embracing the job, a friend and enjoy it, right?
You're rocking with the DJ that keeps the hits coming.
Negativity, let's lift up. This energy's electric, bringing us together. Feeling alive and fulfilled. Shawty saying that I am the one. Who does she think she's talking to? She wants someone who brings unity.
Breaking off another hot explosive mix.
Culture Empire. Numbers don't lie, they testify. Lab books, open case law. Reading every line like a judge on the last call. Turn credit acceptance to a conquest. Took a contract apart.
We're about to take it back.
Gotcha, bitch. Thomas in the lab, books open, case law. Reading every
You're
line like a judge on
rocking
the
with
last
the
call.
best.
Turn credit acceptance to a conquest. Took a contract apart. Made him confess. Consumer finance, that's chess, not checkers. Built a blueprint, now we training whole sectors. From the payment plans to the charge-off sheets. He can map out the money like Manhattan streets. Understand risk.
You're rocking with the best.
Break a deal down, show the hidden obligation. He don't chase clout, he chases precision. Every decimal in place like a surgeon's incision. Supreme elite, we got receipts.
You're rocking with the DJ that keeps the hits coming.
We see a breach, Thomas turn pressure in the long term wins. Dark in the hook, but the numbers still glow. Empire built slow while the cash flow grows. Supreme elite, we got receipts. Every page proof that the squad still knows. Accounting on point, every entry a line. From the pool to right down balance, never behind. He can trace every fee that they padded in the margin. Pull a spreadsheet up, whole case starts talking. Securitization, he can see through the stack. Those trenches trust, bring the paper trail back. They bundle up the debt, try to bury it deep. Thomas read the prospectus like a wolf in the sheep. Litigation mind, he'll cross X and pivot. Turn a weak clause to a weapon in a minute. From discovery to trial, strategy tight, knows which doc makes the judge sit upright. New culture empire, that's
You're rocking with the best.
teams how the system pretends. Supreme elite forming up under his lead, he plant real knowledge like a long-term seed. Supreme elite, we got receipts. Stamped in the ledgers and the court transcripts. Supreme elite, we got receipts. Every page proof that the squad still knows, yeah.
Every claim, every fee, every clause, every plea. If the math don't match,
Gotcha, bitch.
then the truth ain't free.
He could track that trail through the ledgers and lies. Pull facts from the fog, put a win in your light. Supreme elite, they study while the loud ones tweet in the dark. Thomas still reading receipts.
You're rocking with the best.
Supreme elite. Supreme elite.
You're rocking with the best.
I want to say one thing. There is very little people that I have utmost respect for. And I'm not saying this to brownie point or anything because it makes no difference to me. I'm that cut and dry. Lamont is only one of maybe a handful of people, 5 people, that I have the utmost respect for what comes out of his mouth. And you got a great...
All right, I'm going to try to get this out. This is 30 seconds for my man Lamont from the Supreme Elite team. Now, my mindset before I came over here, I was heavy on that sovereign citizen for a minute. And then I got got it out of it. And you just further reiterated how stupid I was, how much money I lost by following that stupid mindset.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
Welcome to another edition of the New Culture Empire Supreme Elite Team. Today we are going to finish up what we started yesterday. I actually had 2 videos I wanted us to get into, but conversations went to a different direction, which I wasn't anticipating, but that's how things go. So today we're going to get back on track, and I want people to put this on your mind while we watch these videos and have discussions around these videos, because the point that the reason why I send these videos out, or I recover these videos, is because it's more on providing awareness rather than try to point out what they're doing wrong. Because although on social media we hear a lot of so-called success rates, but the rough numbers say that collectively we're all doing something wrong. We're doing something wrong. And I know many people don't want to admit it, but not approaching this from like with an attorney from law school and going through those vigorous trainings and getting certified and taking the bar and passing the bar. Pro se, what one person does actually does affect all of us. Administratively, court. When you're acting pro se, that doesn't give you a pass for not understanding how the courts and the rules governing those courts proceedings function. And when you represent yourself pro se, that is not a pass or a green light for you to assert claims that you probably heard, probably got it from a document, or just the whole narrative. That doesn't mean be pro se because of that. Because many people fire their lawyers or don't even want to seek counsel because the attorneys, they're actually held to a different, more strict standard. If an attorney was presenting the claims, majority of the claims that you see online today, they will be sanctioned. They will get in legal trouble. The reason why they don't sanction pro se litigants like that, because they understand the origins and the histories that many people have been misled. So my aim is to bring people from out of the Stone Age. I'm not trying to save the world, but at least the bare minimum, just a bare minimum of popular claims that will not survive in court. The issues that I'm running into is that the popular claims that won't survive in court, this is how a lot of content creators make money off the narrative. This is what people so wholeheartedly believe in. And when you're dealing with people that kind of are leaning towards their own beliefs, the scary part of it all is there won't be any growth in their progression, because if they don't get the intended outcomes, there's a reason why. And in their mind, the reason is the courts know that I'm right. They just don't want to give me my relief. You get what I'm saying? Or they're just trying to stop. They don't want the truth out. People have been trying to expose this quote unquote truth for decades with the same arguments and the talking points that they have done then, that they are still doing today. So, although everybody won't make it to the promised land at one point, at the same time, at least these videos and what people like me continue to do, at least gives you another angle to look at it. At least forces you to have the conversation with yourself. Maybe I am doing something wrong. Maybe I don't understand the court rules and procedures and how this thing goes the way I think I do. Maybe this document that I'm reading does not align with the realities of court. Just maybe. Because at least if you can just have that conversation with yourself, then whatever you decide to do afterwards, that's 100%. If you want to continue to pursue it, just don't be upset. Don't be upset when the rulings and the outcomes do not go in your favor, because you have full warning and you fully understand. So if you want to continue to do it, by all means, that is your prerogative. It's not going to hurt me. But what I'm saying is, if you're actually looking for an intended outcome from it, the reality is you're going to find yourself being more disappointed than the results, than you're happy that you got the intended wins. And the days for people just coming and giving an opinion just because they have a mic and access to a social media app doesn't mean they're qualified to give the opinions that they've given. I mean, you got people that haven't even amassed 10,000 hours of research giving a full-blown opinion on how they think the court and the system works, which is ridiculous to me. So find someone that knows what they're talking about, who has a reputable track record, who understands court, who understands proceedings, who's been inside of it, who understands the nuances, who has legal stamina. Those to be the people you should be, trying to learn from. Not someone that's just going to tell you what you want to hear. So, without further ado, let me get started on this.
Who's participating by phone?
On and for the record, I'm Houston LaShawn DeYoung, more beneficiary. I'm here in my proper person.
What's your first name?
My first name is LaShawn DeYoung. My surname is Houston.
All right.
I'm here in my proper person, my own right, and haven't reached the age of majority.
This is a classic example of what I mean. I know when they tell you to say these things, they tell you because it has legal significance or it's going to make a difference. But when they say things like that in court, y'all do realize the judge is completely ignoring the proper person, the beneficiary, reached the age of majority. They don't care about that. The only thing they care about is you identifying yourself for the record. So all that extra stuff, it has no legal significance. Nothing at all.
I'm a more Aboriginal, America's Aboriginal, Illinois National.
Once again, that national, American national, started from the patriot communities from the 80s and 90s who had deep ties to white supremacists. So just because you throw a more or you put your own spin to it, that whole American national and the ways that people use it today, it kind of actually has a bad ring to it. It really does. Because the term a state, American national of your state, it's now synonymous to paper terrorism for the FBI. That's how they look at it. It's synonymous with that term.
Is
But not a
Kimberly,
citizen of the United States?
He said he's not a person of the United States, meaning he basically saying is his constitutional protections don't apply because you have to be a United States citizen to have these things apply to you. So now he's saying he's foreign. And the reason why he's saying foreign, he's not a citizen of the United States. See, he's not saying I'm not a citizen of the United States as a country. He thinks the United States is a corporation, that there is no country. It's just one big corporation. Not knowing that when they was looking at that statute to justify it, that's been one of the biggest examples when I mean, or when I say a misinterpretation of a statute. 28 USC 3002 is foremost one of the statutes that has been misinterpreted for the last 30 years. And its intent is clear on its face. I went over this, so I'm not going to get deep into it. But just in case, just to put a button on it, get back to the video. They're only talking about in the context of them trying to collect the debt against you, meaning they have to follow the debt collection procedures, just like any other corporation who attempted to collect the debt. That's all it means. If you owe a debt to the United States government or state agency, that's pretty much what it means. It doesn't mean they're a corporation as in the country. They were talking about the corporations, meaning the corporations that the governments use to conduct transactions with people, such as Small Business Administration, or you get a HUD loan, or you get a student loan. You get what I'm saying? Those GSCs, you get a mortgage through them. They're not talking about like a corporation, like in that sense. But that's where the narrative comes in at. Because the narrative is 1933, bankrupts, converted, collateral, corporation. That's that old patriot white supremacist ideologies. They've been saying that since the 80s.
is Kimberly available?
Not a citizen of the United States.
Is Kimberly
Or the United
available?
States for the District of Columbia. Houston Kimberly Denise is deceased. I am the sole beneficiary and real party of interest in this matter.
All right, just a moment. Before the court this morning is the landlord's complaint to recover possession of property. The person entitled to possession of the property is the plaintiff.
Okay, so right there. So this is a foreclosure. The number one thing that's on the court's mind in this moment is who is the rightful note holder, who's in possession of the note, or who has the right to enforce the note on behalf of the owner, who can legally collect this debt under the law. And since whatever state they're in right now, I'm not sure what state they're in, the first thing they're going to look to is their Article 3 and Article 9 of their state versions of the Uniform Commercial Code, not the one that you type in on Cornell Law on a Google search. It's your state law, because each state has adopted their own version of the Uniform Commercial Code and enacted it through their state legislators. So that's what makes it statutory law. There is no federal UCC. This is why if you go into federal court, the federal judges are going to look to the state law to get the interpretation, the ordinary meaning of the statute when taken as a whole. This is why a lot of people fail in federal court, because they don't know how to navigate strategically with bringing federal claims and state claims. It's a strategic way that you have to navigate through federal courts when you're using your state claims as your legal cause of action, but tying it under your federal questions. I executed that masterfully, so I know what I'm talking about. I think I should hold a webinar on court. I really think I do. I think I do, because a lot of people, it gets frustrating.
Due to a sheriff's deed of redemption.
Okay, sheriff's deed of redemption. So this looks like he's in a non-judicial state, but I'll see. So when your house is up for sale in a foreclosure and you get the judgment against you, each state, you have the first right to purchase the home back first. So let's say I want to come buy your home. You're going to get a window. Depending, each state law is different. Their time frames is different, but it's pretty much consistent. Within that time period, you can be the first one to buy the home back. Nobody can buy it back but you during that time period. If that time period elapses, that right of redemption, that's what it means. You have the first dibs on buying your own home back. So if I was coming to buy your home, but you got the money to buy it, by law, they can't sell it to me. They got to sell it to you because you have the right of redemption. But if that time period elapses, then it's first come, first serve.
A sheriff's deed. Ma'am, please don't interrupt. I'm reading.
Not a man, excuse me, I'm a male.
Okay,
I object and
sir.
deny.
Sir, please don't interrupt.
This is what I mean. Belief system, how courts work versus the reality of court works. She's just going over reading over the record right now. There isn't anyone on the other side that's making a statement. So his objection, although it lacks legal basis, it's untimely as well.
I'm reading from paragraph.
You're trying to put something on the record that has not been proven.
Once again, she's reading from the paragraph of the complaint. It's already on the record. You can't object to that. It's already there. This is the initial. You see how it gets off the rails early with these people?
I'm going to have to mute you if you continue to interrupt the court.
If you mute me, then you are violating my rights.
See, once again, remember, their rights are violated when they believe their rights have been violated. Not because there's a statute that they could point to that says their rights been violated. No, not with these people. Just like their debt is paid when they believe a debt is paid. A debt is paid to them when they put their fictitious negotiable instrument in the shredder and don't respond. Then they're going to attach UCC 3603, tender of payment. If you don't, refuse or don't send it back, it's considered paid. See, they was looking at it from a literal meaning, but what they don't understand is the tender of payment in its first initial tender has to be legally recognized United States currency. So you can't create a fake check by putting your social security number as the account number and the Federal Reserve routing number that corresponds with the number on the back of your social security card as the routing number and say, hey, since you ain't send it back or dishonor it, it's legit, because it only applies to legal recognized tenders. So once again, beliefs versus reality.
You haven't even proven you have jurisdiction over this matter. You haven't proven you have.
Judges don't prove things.
Subject matter jurisdiction.
Judges don't prove things.
Yeah, that's a great answer from the judge. Judges don't prove things.
Personal jurisdiction.
Parties
Don't
prove
prove
things.
things.
No, and the judge is 100% correct. I know when y'all read those 1854 cases where the court must have jurisdiction and jurisdiction can be challenged at any time and you can't proceed forward unless jurisdiction is established. See, once again, there's that literal interpretation and the literal meaning of what it says. Jurisdiction can be challenged at any time, meaning you can challenge jurisdiction at any stage of the proceeding. That doesn't mean, they didn't mean you just come to court and say, I want to challenge jurisdiction. See the literal interpretations, because there's a set rules and procedures to challenge the validity of a claim being brought against you. So if you want to challenge the court's subject matter jurisdiction, because that's the only subject matter jurisdiction that you'll be able to challenge, because they already have jurisdiction over the substance of the case. Foreclosure, you're going to be in civil chancery court. Traffic case, you're going to be in the traffic court. Criminal case, you're going to be in a criminal court. In that amity, there's only this. You can flush that down the toilet. All right? So you file a motion challenging the court's subject matter jurisdiction, right? The other side gets to respond, and then the judge will issue their ruling. Or the judge can make a sua sponte determination that it lacks subject matter jurisdiction over the case. In the instances where you're only going to see that happen is always going to be improper servicing. That's it. Improper servicing. That's when the court's on his own accord would throw you improper servicing. It's the only time you're really going to see it. Any other challenges to the court's subject matter jurisdiction is always done as a motion to dismiss or Rule 12b-6. So when their lawyers are filing Rule 12b-6 motions against 99.99% of pro se litigants after they went through all that trouble to file their complaint, it's because basically the lawyer's saying, hey, the claims that you're raising, there's no court that recognizes it. There's no statute that recognizes it. And since the courts doesn't recognize the claims you're presenting, then they can't even give you the relief that you seek. And since the courts cannot even grant you the relief that you seek, then the court doesn't even have subject matter jurisdiction to hear your claims. That's what they're really saying in a Rule 12b-6 motion. This is why when they filed these cases with the Court of Federal Claims, which is another 30-year-old outdated way of trying to extract money out of the secret trust account, the reason why the courts deny him, saying this court lacks subject matter jurisdiction, because there's nothing that deals with a statute, no money mandating statute that you could point to, nothing in the Constitution you can point to. There's nothing on the books, regulations, implied or otherwise, that you can point to that says that the government does hold money in the trust fund for us and that they owe us money from it. So if that was true, people will be winning in the Court of Federal Claims, but every single one of them gets spanked. So, with that being said, subject matter jurisdiction, yes, can be challenged, but you must file a motion challenging it, not go in open court and ask the judge to prove it, because the judge doesn't have to prove anything to you.
That's correct.
No, the judge the court has to prove that it has subject matter jurisdiction and personal jurisdiction over the subject matter.
You are
There you go.
now being
You
muted.
don't have to prove that.
Officer Denham?
This is exactly what happens when belief systems meet court reality. He is a representation of 98% of these spaces. A lot of people think the way he thinks, but I'm glad I'm doing it like this in open court so you can see how it plays out in court.
Thank you. As I was indicating, the complaint to recover possession of property received by the court on October 25th of this year and signed by plaintiff's attorney, who was present on the record, indicates in paragraph 5F that the plaintiff has a right to possession of the property because of a sheriff's deed and the redemption period expired on September 8th, 2022. Is that correct, counsel?
That is, Judge, and the court will note on the complaint, we actually attached a copy of the sheriff's deed too. I believe it's the next document under the actual complaint.
Yes. So can you give me the history of the tenancy?
Yeah, can I do it informally, Judge, without having my client sworn, or does Your Honor want it to come from my client directly?
Anything that he says is impermissible and it's prejudicial.
You notice how he's not citing any court rule, any statute, no substantive law to back it up, because these spaces, they don't operate off rules, procedures, substantive case law. Now I'm going to match my claims to align with that. No, this is what I believe happened. This is what I've been taught. So that controls. But when you line it up and put it under the legal lens, you have nothing that states a viable claim. But since they believe it's so true in their heart, this is where the conspiracy of the courts comes into play.
Statements of counsel in argument or in brief are insufficient for granting of a summary judgment or dismissal.
Yes. So can you give me the history of the tenancy?
Yeah, can I do it informally, Judge, without having my client sworn, or does Your Honor want it to come from my client directly?
Anything that he says is impermissible and is prejudicial. Statements of counsel in argument or in brief are insufficient for granting of a summary judgment or dismissal.
Your objection is
on this matter. He is a third party in this matter. I want my objection on the record.
Your objection is on the record. Your objection is on the record, and your objection is overruled. You're again being muted.
Is a third party.
I need her muted or him muted. Thank you.
Anything that is said scandalous and prejudicial, and
I am removing Mr. Houston from the hearing because of continual interjections, interrupting the court's proceedings. I will later consider whether to find him in contempt of court.
And this is the sad reality of people in court in these states of mind. It's not because he feels the lawyer did something illegal. It's not because he's being unlawfully foreclosed on. The reality is he's about to lose the home. That's all it is. I'm not about to be in this house anymore. That's all it is with all of them. This is the desperation side that I'm talking about, where you have to try something to save your home.
Judge, I removed his chance ability to unmute himself if you want to.
Thank you. That'll be fine.
Yeah, you can't unmute himself anymore.
All right. Okay, counsel, what I was asking for is basically when the tenant took possession and the historical facts as to the sheriff's deed and the redemption period.
Right. Judge, so the way, and I can have my client sworn in to identify for the court the...
Okay, before he goes, so before he says anything, I'm going to take a guess right quick. So I think that his client actually purchased a home at the sheriff's sale. And normally you'll get real estate investors that will come purchase the home. And then they'll come to you like, hey, I own this home now, but if you still want to stay in it, you could pay me rent. That's kind of what they do. So normally, because I know someone that's a real estate developer, and I know people that buys homes for people. So normally what they'll do is they'll get the home, and immediately they're not trying to kick the homeowners out. They just convert the mortgage into a tenant agreement if they want to. So that's what they want to do, because it allows them to recoup on some of the money they paid until it's time for them to, if they want to make a move later on down the line. But normally they'll show up and be like, hey, I own this house now. Sorry, but you want to rent it, you can rent it. That's pretty much what they, what the real estate investors do.
Oh, sure.
The actual scenario is the homeowner, which I believe are the Houstons, were residing here, and they had a mortgage. The mortgage fell into to default, and the property was placed for foreclosure and went to a sheriff's sale. And my client was
It went into default on the mortgage or on the tax bill?
on the mortgage, Judge.
Okay, and who held the mortgage?
Genesis Genesis Credit Union as reflected in the sheriff's deed.
All right.
And my client, when it was put up for public auction, my client actually was the highest bidder.
Told you. So I figured he ended up purchasing the home. I told you, yeah.
Concluded that transaction through Oakland County, and then the sheriff's deed on the mortgage sale was issued and then ultimately recorded after the 6-month period of time. So we're here today. No, there's been no participation, and the court will note. I mean, you heard a little bit this morning on the record, which is why you muted the defendant. There were some documents filed in this matter by Mr. Houston.
And I can only imagine, I can put my life on the line what type of documents they were. I can only imagine what he put on the record. I can see all the documents now. The same documents that they run around selling today in these spaces.
And if the court has read them, that's great. But it's pretty much it's the kind of things that he's saying, nobody has jurisdiction over him. You can't take away the property and whatever. Bottom line is he had a mortgage, went into default. We were the successful bidder at the sheriff's sale. 6-month period of redemption has passed. No payments were made, and we want to take possession.
So in this state, he has 6 months. 6 months. Right of redemption. 6 months to pretty much purchase the house back. So this is a non-judicial state right here. So for my social media teachers, what do you think is going to happen when your client is in a active foreclosure in a non-judicial state when they reach out to you? It's not like it's emotions and pleadings back and forth. In reality, in order for you to stop a foreclosure in a non-judicial state, you have to go file a motion for temporary restraining order or injunctive relief, which is one of the most extraordinary remedies that the federal courts grant. And the likelihood of success on the underlying merits is one of the determining factors of whether they're going to grant a motion for temporary restraining order, because they're rarely ever granted. And the likelihood of them putting a temporary restraining order, a temporary injunction, and ordering them to respond to your motion for temporary restraining order is 0 to none. If you even get the judge to even order the other side to respond to your temporary motion for temporary restraining order, or TRO or injunctive relief, you're doing something big, because they usually deny those on their own within a couple of days after being filed. It's a totally different ball game when you're in a non-judicial state, because outside of the motion for temporary restraining order, the foreclosure sale has to take place first before you can't file any motions with the state to stop a foreclosure sale. You got to go to the federal courts. And the odds of them stopping that is 0 to none. Slim to none.
Okay, thank you. Mr. Houston, I have a question for you, and that is whether within the 6-month redemption period, you did anything to redeem the property. Officer Denham, we need Mr. Houston unmuted.
I've entered onto the record in that first case that third party was just talking about, proof that mortgage has been discharged by Genesis Credit Union.
Okay, so I think I see where he's going with it. He thinks that just because someone paid the mortgage, paid the balance, that means his obligation, the debt has been discharged. So I'm not accepting this premise, but let's just say for the sake of conversation, it played out that way. That means this I can only imagine it was hundreds of thousands of dollars. He was the highest bidder. So that means he took hundreds of thousands of dollars and just voluntarily paid off the debt for the Houstons without getting nothing in return. You get what I'm saying? You see how when they don't think far behind how their claims look and what they say. They know it's always for the moment thinking. They never think down the road. They never analyze what their assertions are, how it's taken, how the other side can respond to it. It's all, I say it, I believe it, it's true.
And it was discharged before October. It was actually discharged in July.
What do you mean by discharged?
It was discharged. The mortgage is paid in full, discharged. And it was entered into the record of the first case.
I have several filings.
It was even over.
Did you file
The
that?
redemption period was over. I didn't file it over. I filed it in the first case. It's still evidence in that first case. That
Okay, one moment. Attorney Hirschfuss, am I saying it right? Hirschfuss.
I still object to him even speaking in this matter. He's a third party intervener.
He's going to speak.
No, that's not how he's using the term incorrectly. He is not a third party intervener. He is the attorney for the plaintiff. He can speak. Let's just stop all. Oh, God Almighty.
That's my decision.
Everything that he
Please
said
don't
is
interrupt.
scandalous and
Okay, you're muted again.
prejudicial.
Sir,
I see. This is part of the sovereign citizen mindset, where anyone, basically, what they want is to file all their documents and nobody says anything back, and they just give them what they want. So when they get pushback or challenges, which happens in legal court, then they want to file a lawsuit against the lawyer for responding to the complaint on behalf of his client. They want to file a lawsuit against the judge, all because the judge ruled against them. So when you see people online in these panels and they come up on the panel and they start talking about they just filed their lawsuit against the judge without even asking the question, the underlying reason why they just filed a lawsuit against the judge is because they gave them a ruling they didn't like, or they ruled against them in the foreclosure, or they ruled against them in some type of ruling they didn't like. That's the only reason why they're filing a lawsuit against the judge. Not because the judge created a criminal act. Never mind the fact that judges are immune from legal liability while performing their duties as a sitting judge. Never mind the fact that you won't even win that anyway. It's a emotional, I didn't get my way. I thought I was right. And the real reality behind all of it is they're filing these lawsuits against these public officials. That's their way of telling themselves that they're still right and not wrong, because it's harder for them to accept that they was just wrong and they had to lose their house behind being wrong. So it's easy to go file a lawsuit because they're telling themselves they're still right. They just violated their rights. In reality, they've been wrong from day one.
did you obtain a copy of the original file?
No. Let me just indicate for the court what the discharge he speaks of.
Yes.
The Genesis discharged the mortgage because we paid it off. So it's by the way, it's not a discharge, it's called a satisfaction of mortgage.
Yes.
And it's dated on May the 24th, 2022, and recorded in Oakland County Register of Deeds Office on June 2nd, 2022.
All right, I have not yet adjourned it to continue, sir, but go ahead. You were going to read the discharge?
It says satisfaction of mortgage. Know all men by these presents that Genesis Credit Union of Auburn Hills does hereby certify that a certain mortgage dated May 3rd, 2018, made and executed by LaShawn Leon Houston and Kimberly B. Houston, husband and wife, to Genesis Credit Union, and recorded in the Register of Deeds Office for the County of Oakland, Michigan, the lot and everything, the tax parcel and all that, is fully paid, satisfied, hereby discharged as of today's date, 5/24/2022.
Thank you. And that is the same document that the attorney for the owner has read into the record, sir. And
Right. So when a mortgage is paid, you're going to get a satisfaction. Now, my bad. Now, if it was paid by somebody else, they're going to get the same satisfaction. And then they're going to get a sheriff's deed, and they're going to get all the documents to come with it. If it was set off just by, legal reasons, you're the only one that's going to get that. And then you're going to get the tax and escrow, because the tax and the escrow, the title company actually tells you who paid the mortgage off. That's why I went and got the title, the tax, called the title company, because yeah, it was done the way I anticipated it was going to work. But in his case, somebody actually brought us home. That's why they have their copies as well.
so he's indicated that it's his client, Mr. Or Shepherd Properties LLC, who satisfied that mortgage by paying it off. In what amount, sir? In what amount, Mr.?
Judge, the bond found with the debtor is presumed to be paid. He has no mortgage with his name on it. He has no proof that he's an adverse party or that he's a bona fide party to this matter.
And everything he said, you could put it on a toilet paper and wipe your behind with it, because he was the highest bidder at a sheriff sale. So everything Mr. Houston just said is moot. We call that a moot point in court.
He has no proof that he gave any consideration to the sheriff, and the sheriff gave any consideration to me in order to sell my private property in the first place, which is actually owned by a trust. And the Oakland County Register of Deeds and the Oakland County Treasurer has been noticed of that property has been transferred into trust as of 2021.
Okay, so this is the typical thing that you see in these spaces. You get into mortgage trouble, you find somebody online, and they tell you to put your property into a trust. What they all fail to account for is when you put the property in the trust, assuming that you transferred it correctly, was the underlying debt satisfied before you put the property into the trust? I told you, the underlying debt is one of the main things that still escapes 98% of people in these spaces. The underlying debt. This is why with these consumer claims, they'll file FDCPA, FCR claims, because they're trying to attack their behavior in the act of collecting the debt. They're trying to see if their rights were being violated in the course of collecting the debt. Very few people structure their classes, their course, their services that is attacking the underlying debt. So this is why they transfer them into a trust, because they think that once the mortgage is in the trust, nobody can foreclose. But clearly, the corporate veil was pierced, because once again, they think that just because you put notice on something that has any legal effect. They think that just because they notice the recorder of deeds and the treasurer that it has legal effect. They think that as soon as it sends it off, it's law. Just like Ellis Raspberry. He thought the restraining order was lifted as soon as he filed documents. That's why he went to jail for violating the protective order. He filed a document, and just because it hit the record that the protective order was lifted. So even in that case with Ellis Raspberry, this dude has the same mindset. And normally you see these mindsets in the sovereign citizen communities. Whether you call it patriot, whether you call it Moor, whether you call it aboriginal, whether you call it God's law, universal law, Bible laws, Bible thumpers, where you call it being private, standing on your rights, know your rights, equal footing. It's all a variation of the sovereign citizen movement.
So at what point in time did the sheriff give consideration to me or my trust for my property in order to sell it in the first place?
There's no requirement for a sheriff to give consideration to you because you think that they had to because your trust owns it. The problem is, I don't give a damn if you transfer the mortgage into the ancient tomb of Kemet. If there is an underlying debt that has not been legally satisfied, the creditor can still reach the assets of the trust. And this is why they go put their homes, their cars in garages and hide them. Or has somebody sitting in the passenger seat when they walk to the store. Because if you knew you satisfied the underlying debt legally, you won't have to hide your vehicles. You won't have to put it in a garage. You won't have to see if it's legit, if it worked. You won't even have to go to the DMV and get a title. They'll send it to you. They'll send it to you in the mail. They'll do all that work and they're going to pay the taxes on it. And then they're going to send you the title in the mail. Instructing the DMV to release the lien off it and issue a brand new title. Now you have free and clear title. Now, if I want to transfer my title into a trust, see, I can do it without worrying about a creditor coming after me.
Sir, you would have to consult an attorney about that process.
I don't want to be an attorney. I'm here my own proper person.
And that's the number one problem in these spaces. They think attorneys does nothing but sell them up the river. I've learned so much from attorneys that you'll blow your mind away. But this is the problem with these spaces. Anybody that's in the professional fields, it's like oil and water. They don't want to learn from the professionals. Want to know why? Because the professionals are going to be saying things that goes 1,000% against their belief systems. This is why everybody thinks that they're equipped to just handle their own affairs and fight their own affairs. Because everybody told them that it's way easier than what it is. Everybody told them that you can do this quick, fast process and you don't have to use a percentage point of your brain cells to get it done. Hell, all you got to do is just sign the template and send it in.
My own right. I'm suing you this. I don't need no attorney. He's no guardian over me. I'm not a minor.
All right. Thank you.
Typical sovereign citizen rhetoric.
You.
Now,
you're going to be muted now in order for me to address some of what you.
Can I have your name, please?
Now he's about to. It's the same playbook. You get mad at the judge. Now you want the judge's name. You probably want the oath of office, the bond number. Now you're mad at the judge. Typical sovereign citizen playbook. Whenever they're not getting their way, they want to start going after the judge now. It's the same thing. And this is one of the saddest parts of these spaces. Everybody who follows these beliefs, they all have a belligerent disposition. They're very difficult to deal with. You can't even talk to them. It's just an evil spirit that just comes down and hovers over their souls as soon as you go down these sovereign rabbit holes.
My name should be on the screen. Or you're on the phone.
I don't have the screen open. I'm on the telephone. Can I have your name, please?
Yes, when I'm ready to give it to you. When I'm ready to give it to you. Please mute Mr. Houston so that I can address his issues. All right, so we will adjourn this until, or continue it on January 18th, 2023 in the afternoon. The docket time will be stated on the notice of hearing that is mailed to the parties and counsel.
Very good, Judge.
And the reason for the continuance is for the plaintiff to present the satisfaction and the recorded deed. And
Told you. See, why do you think she wanted them to produce the satisfaction recorded deed? Because I'm pretty sure they have it, but if somebody else paid it off, they get all that too. If you was able to work your magic, you're the only one that gets it.
Mr. Houston, my name is Judge Sheila Miller Martin. All right, we can unmute Mr. Houston before closing for today.
Could you repeat that, please? Repeat that, please. You said Sheila Miller Martin?
That's correct.
And none of what he's about to do is going to help him get his home back.
Have you taken an oath to uphold the Constitution?
What did I tell you? First thing they want to ask for, did you take an oath to uphold the Constitution? Rhetorical questions. Are you standing on your oath? Do you have your badge? It just gets, and this is hundreds of thousands of people who do the same thing every day.
Judge.
Sir, I don't answer those types of questions. I'm not
Have you taken an oath? Have you taken an oath? That is a question for you, Judge.
Goodbye.
I do say you taken an oath.
All right, y'all. So that's the end of that proceeding. Judge Martin, she definitely.
Conviction is for review on ticket number U40128557.
This is a traffic court now. It's a traffic case.
The conviction is disorderly conduct. Good morning, please say your name.
No, I'm sorry. Disorderly conduct, criminal.
The record.
I'm here, Your Honor. My name is Carlos. My name is Carlos of the Durham family, and I'm here as executor of the estate named in this matter.
What'd I tell you? What'd I tell you? Well, it never fails. That Carlos of the family name, once again, the family name of this, that is the old patriot, white patriot movement rhetoric. They started that. The executor, they started that. David Clarence made that term popular. The executor letters. He had connections with Gene Keating. Gene Keating had connections with Roger Elvick. Roger Elvick was the popular person who created the whole "there's a secret treasury trust account. He was the one who spreaded that. Roger Elvick had connections to Terry Nichols, who was a friend of Timothy McVeigh. And all of them had deep connections to the white supremacy group. Why do you think the patriots, the ones who are part of the patriot community, you never see no blacks within their ranks? You never see it. Like you never see any blacks within their ranks. In the official patriot movement. Why do you think it's predominantly white?
And beneficiary. And I appoint you, the judge, as trustee.
There's documents that I've read on that stuff that dates back to 1997 when they were saying the same thing. Like it was a whole script for court. 1997 saying the same thing. You are not in probate court. It's not wills and estate. You're not in probate court. You did not get a death certificate. You are alive. There is no estate in this matter. And the only reason why they say these things is to avoid accountability. Oh, it's not me, it's the estate. Here, I accept the charges. I tender it back to you for full settlement and closure of the account. They was doing that up until like 2004. That was that patriot movement crap. Get the indictment. The indictment is a bill of exchange. That's what Gene Keating was saying. Like, they don't even understand the origins of the things that they spew online. I know more of the origins than they do about their own belief systems. Every time I hear a person talk online, I immediately go back to the year in my head. I say, oh, that's like 1995 right there. Oh, coupon method, creating your own checks. Hey, they was doing that in 1996. They stopped that in 1999. Made it a federal crime, start prosecuting. Alert 9910. The Office of the Comptroller of the Currency and the FBI started a joint investigation. And because before you was self-creating your bills of exchange, they were calling them site drafts. So it was the same check, they were just putting site draft on it. They was doing the same thing, Federal Reserve routing number and your social security number is the account number. They was doing this over 25, damn near 30 years ago. So when you send this stuff all to the IRS, you think you're doing something brand new because you just purchased Vince's execution class. All you're doing is running yourself right off the fiscal cliff. Because accounts are being reversed, tax bills are being sent. And when they get hit with tax bills, because they always try to find a way to find a teacher to help them keep the money. And then they run offline for a while, go defect down to Telegram and start their own Telegram groups to try to figure out how to keep the money. Wanna know why? Because I know someone that was in that group. So I seen all the screenshots. Everybody that got a check that took that Vincent Edwards crap and got reverse. What's her name? Michelle, that buy from yourself, loan to yourself, who is following Patrick Devine. Oh yeah, there's no original teachers. They're not going and getting this stuff out the mud, creating their own stuff from scratch. It's all passed down rhetoric.
My name is Carlos. My name is Carlos of the Durham family, and I'm here as executor of the estate named in this matter and beneficiary, and I appoint you, the judge, as trustee to dismiss this matter.
You can't appoint me as trustee. I'm not the trustee. I'm the judge of this matter, and we're not dealing with any beneficiaries or any of that. You're dealing with the defendant, and it's not.
And it's just as simple as that. It's as simple as that. You are charged with disorderly conduct. What is that? One of the lowest of misdemeanors? What is that? What do you pay a fine? They give you plead guilty, pay a fine. And you turn the normal, simple, everyday meanings into something so esoteric. Every word has to have a deep 5-layer, multi-tiered meaning. Oh no. If the judge asks you, do you understand the charges? Don't say you understand, because what they're really saying is, do you stand under the charges and agree to be the surety on the bonds that we're about to issue? So if you say you understand, it really means you stand under and you're about to commit yourself to being a surety. Are you serious?
My understanding that you are Carlos Durham and you're the defendant in this matter.
Do I have a right to subrogation?
Just like the last person the other day, the right to subrogation. You know what? I know, and I know that document as well. The right of subrogation came from that old 2003 packet about the international use of international bills of exchange. And y'all know what I'm talking about, because many of y'all still use the rhetoric from it today. It's an old packet. Came out the early 2000s from the Patriot community about the use of the international bills of exchange. And it was basically saying you're subrogating your estate for the payment or for you. So that surety, subrogee, taking 1855 Supreme Court cases out of context. Yeah, of course. Right of subrogation, of course.
Does the prosecutor give me the right to subrogation? Do I have a right to subrogation?
I don't know what that is. What's subrogation?
It's so old and outdated. It's like almost like damn near 300 years old. It's so outdated. It's not even used in the ordinary course of today's society. It's not.
I require subrogation.
What is that?
You don't know what subrogation is, Your Honor?
I don't.
And read it from a script. He just picked up a piece of paper.
I don't.
Okay. Are these proceedings being recorded?
They are.
is your bond and oath of office valid, current, up to date, and still in effect?
Reading from the, that's old. That's 1990s. He took it back to, I'm telling you, 1990s. That's the whole deep sovereign citizen right there.
I'm an active member of the bar.
For the record, please present your bond and oath of office to the court. The prosecution bonded for this matter.
The prosecutor is not present right now, Mr. Durham, but I don't have to do that. So
I'm here at special appearance, and I'm here for the purposes of demurrer. All rights reserved under my full God-given name, Carlos Lorenzo Durham, as indicated as by the birth certificate. Right here.
Mr. Durham,
I am also the sole beneficiary for this legal entity.
Mr. Durham, everything that you're stating does not apply to this court, sir. So
the Supreme Court and the Constitution doesn't apply to this court. What jurisdiction is this court operating under? Common law or admiralty jurisdiction?
What I tell you? What did I tell you? It's old ancient Supreme Court cases and Constitution and common law or admiralty. Never mind that admiralty only deals with the high seas, the oceans, shippings of goods, transactions, commerce using the oceans, not a creek, not a pond. Never mind its federal jurisdiction is limited to those, and piracy. Never mind that. In their minds, ooh, they got secret zoning codes, so they zone them, and that's the naval zoning code, so it's admiralty because of that. Okay, can you find me a statute or show me where you went into state court, simple traffic case, and got your case dismissed because the court declared that they didn't have jurisdiction because there was only two types of jurisdiction, common law or admiralty or maritime? Can you show me that? And this is when it gets crickets. This is when the conversation online stops. This is when the back and forth in the comments stop. They never respond. They just go away. Of course. But remember, the theme of this live stream is belief systems over reality.
Because those are the only two jurisdictions that's mentioned in the Constitution. What jurisdiction is this court operating under?
Either we're operating under state law and the law is statutory.
Yes, state law, statutory law. You want to know why? Because they have authority per the 10th Amendment to create their own laws and rules and ordinance to govern the safety and welfare of the states. This is why, since you said in the Constitution, disorderly conduct is not mentioned in the Constitution. So the states are well within their rights per the 10th Amendment first, and then further grant by their state constitution. But they don't want to talk about the 10th Amendment. And remember when I said they'll take a term and just apply in the literal confirmation bias? So when they say reserved to the states or the people, they really thought they was talking about the people like you and I. Meaning the state legislators has the authority to create the rules and laws of each state. And they are valid, binding, and they don't need your consent before you follow them. And no, Marbury versus Madison does not say what you think it says. Just because you don't like a rule or law doesn't make it unconstitutional. There's plenty of laws that I don't like. Doesn't mean I get to ignore them or violate them just because I believe it goes against my best interest and my benefit. So I'm going to sprinkle, oh, it's unconstitutional. I don't got to follow it. Right.
Is it operating under statutory jurisdiction, Judge? Because if it is, I need to know the rules and procedures for statutory so I can defend myself. Could you tell me where I can find a copy of that?
Yeah, in the court rules and the court procedures. Yep. The same way you found that script on Scribd online somewhere is the same way you can find the rules and procedures so you can properly defend yourself. It's the same place. You're being disingenuous. You're not going to look it up. You don't want to look it up because your belief system already has your mind made up.
Mr. Mr. Durham, we're operating under the law of the city. These are city ordinances, and these are.
Those are not laws, ma'am. I'm American State National, ma'am.
I'm American State National. Who started that? That's that Patriot Movement stuff. State National.
Mr. Durham, these are your options today. This is, one's already set for review, because it looks like you already made admissions. It looks like you pled guilty to one charge.
I didn't plead guilty to nothing. I didn't plead guilty to nothing, ma'am. I didn't plead guilty to nothing, ma'am. A judge is operating.
Mr. Durham,
I plead guilty to nothing, ma'am.
Mr. Durham, how this can work, we both can't talk at the same time. So you need to be respectful and let me say what I need to say. I'll let you say what you needed to say. So you need to let the court speak now. So you are.
Remember the belligerent disposition, the belligerent attitude. That is the common hallmarks of dealing with a sovereign citizen. They'll reject the name all day, but their talking points, what they put on pieces of paper, how they break down the law, it all has the hallmarks of it. See, they think that if they just reject the name, then they're not one. They will ignore the fact that everything they say out of their mouths, what they put on their piece of paper, what processes they done, were done by the same ones decades before who actually went to court and said they were a sovereign citizen.
Already pled guilty, sir, in 2017. Or no, your plea date actually was October 4th, it looks like. And you were charged with offer to engage the services of another for an act of prostitution. It was amended to disorderly conduct. And so we're here for a review on that matter.
AKA, he got caught in a sting operation. He tried to get Shorty to do something for two something, not understanding that was an undercover. Damn.
Have two charges of drug license not valid or improper license. The offense date is October 18, 2020. And then there's another drug license not valid or improper license charge with the offense date of January 14, 2021. Now, today, you can either set these for, they're already set for a pre-trial. So you can set this for a trial, which it can be a bench trial, where the court, meaning the judge, myself, would decide if you're guilty or not of these offenses, or you can set it for a jury trial. Those are your options, sir.
So my option today is not to challenge jurisdiction, because when jurisdiction is challenged, everything must stop and jurisdiction must be presented. You must prove the jurisdiction.
What did I just say 15 minutes ago about jurisdiction? And how they take that as a literal interpretation just to yell out, I want to challenge jurisdiction. I just told you. And they're doing the same thing. That is not the proper way to challenge jurisdiction.
Right now. Everything must stop and you must prove your jurisdiction right now.
You're incorrect, sir.
Yes, you are 100% incorrect. And everybody in these spaces, they all think the same way as you. Many of them, they all think jurisdiction is something that they can just blurt out their blabbling gums and everything is supposed to just stop until you have a dialogue, back and forth rambling session on why the court don't have jurisdiction.
Ma'am, I'm incorrect. Your oath of office says you're supposed to uphold the Constitution and all laws pursuant.
What constitution do you think they talk about? Because I know you're going to ignore the state constitution as well.
The Constitution says I have rights, and you're not giving me, you're violating my rights.
And I'm sorry, y'all. This is how they all think. As soon, they don't, never mind that he's been wrong 1,000% as soon as the proceeding starts. But since it's not being recognized, they believe their rights are being violated. This would lead to frivolous filings left and right in these courts because they're filing complaints under false premises, under belief systems. These are belief system lawsuits, not realities and factual allegations to back it up. That's just like when they was talking about the derecognition. So when you deal with someone that really understands corporate finance, they're going to look at little teeny words that you say. So they think that derecognition occurs because you sold your asset to a bank. In reality, anybody that's in the corporate finance world knows that that is 100% false. You don't sell no asset to a bank because there was no contract or an agreement for them to buy and for you to sell. You can't automatically convert the promissory note and make it say what it doesn't say. Because on the face of the contract, you signed a promissory note to pay back the debt. You did not sign an agreement to sell a security or asset to the bank. You get what I'm saying? That part of the accounting has nothing to do with the consumer.
By not telling me what jurisdiction we're operating under. Prove your jurisdiction, ma'am.
I'm not violating your rights, Mr. Durham.
Prove your jurisdiction, ma'am.
I'm not prove my jurisdiction.
So yes, you do. The jurisdiction, when it has to be proven, must be proven. If you're exerting authority over me, you must prove your authority.
That's wrong. If the court didn't have jurisdiction over you, why are you in court anyway? You just waived personal jurisdiction anyway. So why are you? I've never met so many people who are so scared of these policy enforcers that will show up to court just to say the court don't got jurisdiction. Well, if they don't got jurisdiction, why are you showing up to court anyway? They don't got jurisdiction, don't show up to court. Well, if you don't show, they go, well, then, hey, stand on it. Don't show the, oh, I'm going to go to jail. No. If you're going to stand on it all the way.
Your jurisdiction, ma'am.
Mr. Durham, what we'll do is we'll set this for a jury trial. And so
I want my peers. I'm an American state national, so I get 6 of them.
Man, she needs to shut this dude down, stop letting him talk over her and interrupt her. You know, she's showing utter disrespect and no respect for the court. She needs to get a grip on that.
No, brother. That's how they all operate. That's how they operate on the panels. That's how they operate in court. They don't know any better. And they're wrong from the time they open their mouth to the time they log off. They just be wrong, mixing 5,000 processes into one, making it up as they go, always trying to protect from the I got your moments, can never be wrong. Everybody's wrong but them. Feel threatened because they're trying to profit and make money off that garbage they selling. So they always got to think the next one's just trying to make money when in reality, that's what they're trying to do. Gaslighting and projecting.
Nationals as my jury. I need the prosecution to send me my right to subrogation in writing. I need your oath of office and your bonding information so I can make sure you are who you say you are and who you claim to be and what your duties and responsibilities are. All public officials must be bonded. I need all of y'all for full disclosure. Am I getting full disclosure right now, ma'am? I need full disclosure before I can make any decisions.
I've told you all that. So
no, you did not tell me all that. I need the name and the address of your bonding company and your policy number to make.
What? Typical sovereign citizen. Even the ones who say I'm not a sovereign citizen, they'll bring their ass on the panel and say the same thing. Call them a sovereign citizen? I ain't no sovereign citizen. You just said the same thing they were saying 25 years ago, and they admitted they were sovereign citizens then. No, they didn't.
You're rocking with the best.
No, they didn't. I'm only saying no, they didn't because I don't want to be wrong.
Make sure your oath of office is current. I need all of that.
That doesn't apply here, Mr. Durham.
Really now? The law doesn't apply to you. You're above the law, what you're saying.
So I'm going to set this for a jury trial, sir. What I'll do is, do you want to retain your own attorney or are you going to represent yourself?
Ma'am, I'm over here for the one purpose of subrogation. Nobody's giving me nothing what I asked for, but you keep trying to force yourself on me.
I'm not forcing anything. You're here for something that doesn't apply to the court, Mr. Durham. If you're here for
so why don't you dismiss the case? Because I was not driving, I was traveling, man.
As a defendant, you're not here.
He wasn't driving, he was traveling now. Oh God. You see what it does to the minds of these people? And they think that they're normal functioning citizens. They think that they think all this is normal. They think they think they got it all down pat. I'm telling you, this space is starting to turn into a MH, an M health crisis. It is. It's starting to turn into an MH crisis. It is. And they don't even see that it's starting to affect how they function in the world. Can you imagine walking around this world thinking you don't have to pay nothing back? Can you imagine the destruction that's headed your way with that mindset? You don't got to pay back an auto loan. You don't got to pay back a mortgage loan. You don't got to pay back a credit card. You just go all through life doing the bare minimum to get approved and with no intentions on paying. But these are the same people who want to talk about God and the spirit and the universe when everything they're doing is going against universal principles. You notice it's always the spiritual, ancient Kemet, Egypt people who always gets it the worst. It's always the spiritual ones, always in a bad position in life, always desperate to sell something. If you strip them offline and just follow them for a day, nothing eventful goes on in their life. Like it's really sad to be those people online.
No, I'm not your defendant, ma'am. I'm your beneficiary, ma'am.
You cannot come here and tell me how it's going to work. That is not how it goes.
Yo, it's always funny when they say they're not driving, they're traveling, but nobody says, it's normal to say I'm driving a car, but nobody says I'm traveling in a car. So I don't know. I mean, I just find that funny. That just came to my mind. I thought I would share with y'all, but think about it. They're always saying, I'm driving, I'm not traveling. I mean, I'm traveling, I'm not driving, but nobody says I'm traveling in a car. They always say I'm driving a car. I don't know if it makes sense. Let me know what you think in the comments.
So I need full disclosure. Am I getting full disclosure?
Absolutely.
Yes or no?
Yes.
What jurisdiction is this court operating under? Common law or admiralty jurisdiction? Which jurisdiction is this court operating under?
You notice how they always they'll add what jurisdiction this court operating under, and then they always try to force the only two answers. Common law, admiralty, or maritime. Which one is it? It's neither. Well, you notice that it's a disingenuous question. That I just need to know the nature of the cause and what jurisdiction so I could properly defend myself. That's the script. The script tells them so I can properly know how to defend myself. And as soon as they tell them the actual jurisdiction they're in, what court they're in, it's like clockwork, never fails. Well, according to the Constitution, there's only type of jurisdiction. And it's like the response is just, it's like I don't get it. I really don't understand how these people think.
Statutory jurisdiction?
Jurisdiction of the city of Detroit.
Is that statutory? Is that statutory? The city of Detroit don't get no rules, the Supreme Court or the Constitution.
You see what I'm saying? They all think the Supreme Court and the Constitution, like, they don't even understand the constitutional limits. They don't ever want to talk about the 10th Amendment, which gives the states the powers to create their own laws. Nothing about this proceeding was expressly mentioned in the Constitution. Nothing. So if it's not expressly mentioned in the Constitution, that means the states never intended on ceding that power to the government. That means the power remains with the states. They all think that the federal government is their friend, that they can use the federal government to overturn any state ruling they don't like Ellis Raspberry. You notice how he keep going into federal court after he loses a state case, trying to get the federal courts to overturn the state ruling that he's been trying all year? That man done filed about 9 or 10 different amended complaints. He just keeps filing lawsuits every time it gets dismissed within the same week. And you want to know why he hurry ups and keeps filing lawsuits as soon as it gets dismissed? So he can always go back. So he can always go back and be like, nah, the case still active. What person do you know who's been filing lawsuits since January and have yet to actually even serve any defendant in the federal court. How's your case is still active and you've never even got to the serving stage? Because his cases keeps getting dismissed off the break, and then he just files another lawsuit. Dismiss, files another lawsuit. Dismiss, files another lawsuit. Dismiss, files another. I'm trying to figure out why he's not labeled a vexatious litigant at this point.
It says if it tries to do that, everything you do is null and void. The Constitution overrules the law of the land, and that's what I'm under.
In order to be heard by the Supreme Court.
Valerie, $2.4 trillion lien listed on the Department of Agriculture listing real men. Okay, how's that benefiting you in your everyday real life? Nothing. And the real woman as the real estate. Once again, how is that benefiting you in everyday life? Nothing. And they must provide their delegation of authority. Sovereign citizen. See, show me that you've recovered 0.001% of that 2.4 trillion. Told you, remember, they think that, hey, I know what's going on, and that's all I need. Well, how does that translate into, well, first of all, it's the question. What is knowing what's going on beneficial for you in real life? Zero. Okay, at that 2.4 trillion, have you taken yourself out that equation and recovered proceeds or whatever? Zero. Okay, the delegation of authority. How is asking that question going to benefit you in any way? Even though that's the same delegation they've been asking for 30 years from the sovereign citizen movement, gets you nowhere. This is what a classic example of what I mean. They put their energy and time into things that bears no real fruit in real life. It bears none. She hasn't even smelt a percentage point of that 2.4 trillion. But on social media, it's good just to know so you could go online and say, hey, they got 2.4 trillion in the department of this. Yay. That's it. So when faced with that, now when the reality sinks in, this is where the lying about their results come into play. Oh, I was able to get those acres of land. Oh, I was able to get my 100 acres in the mule. Always calm down. Oh, I was able to get that 100 billion. Always under avatar. 100 billionaire spends 12 hours a day online and in these apps. But you got 100 billion out the deal. Right.
First go to the district court. And
No, ma'am, that's not true. That's not true, ma'am.
Then you can appeal it, but as of now,
I have to see the lawyer's bond, I have to see the attorney's bond, I have to see the contract you have, so I can.
Do you want to retain your own counsel?
This is that all crimes are commercial, 27 CFR, and once again, another misinterpretation of what they read. You know why they don't like what I say? Because when I say they misinterpret it, because they've been doing it and believing it for so many years, so it's just hard for them to believe that they're wrong. Because they realize they wasted all this time and spent money on it for nothing. This is why they always believe that they're making progress. But as soon as you actually stop and just look at them, there's nothing that they've done that's had any valid effect. There's nothing. Never left first base. There's people that have been in this space for years, still on first base. They don't believe they're on first base, but most definitely they are.
It just looks like that you're supposed to pay the fine of $50. So we'll just have you pay that on the next day, by the next time you come back, which will be January 17th. So you need to pay the $50 by January 17th, and 8:35, which is your next court date. And then your jury trial date is February 7th at 1:35. All right, so you are all set, Mr. Durham.
And all of none of it worked. None of it worked. Now, this one right here, this is the subtle sovereign citizens. This is not the belligerent one. These are the passive and smooth talking ones. But you'll start to see a twinge of it come out.
Statement, please set a record for T.R. Butler. Yes, Your Honor, thank you. This is State of Indiana versus T.R. Butler, cause number 64D012306F65582. Defendant appears in court in person and with counsel, Mr. Steve Pribble. State of Indiana by Gary Garman.
State asking for a jury setting?
I am, Your Honor.
Okay. I want to note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday. There were some documents and things mailed to the court. Do you recall doing that? You recall sending this to the court?
I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file, but I just want to note for the record that we don't permit what's called hybrid representation. Okay, so you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. You understand that?
Yes.
But they don't care. It's not uncommon for a pro se litigant to ask their attorney to raise frivolous claims. The attorney says no, because I don't want to get sanctioned for you. The attorney refuses to do it. So then the pro se sovereign citizen will file it on their own, not knowing that if you're represented by an attorney, the courts are not going to see any of your stuff. They're not going to entertain it. So this is when pro se litigants actually fire their attorneys. They don't really fire their attorneys because the attorneys is not really working on their behalf. They really fire their attorneys because the attorneys won't file those sovereign citizen arguments.
Do you understand that?
Yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon, or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record. Okay? Just so you know.
Mail that to the court.
And this is the part right here where belief systems ran smack into reality. It's no worse feeling than believing something for so many years just to all find out that you've been wrong. Your whole foundation was built on faulty grounds.
Third, I didn't mail it to, that's private that you have.
Right, the private side of the court. That's another patriot, sovereign citizen belief. The private side of the court. You got the public side, you got the private side. See, they deny in public, but honor in the private. Right, sure they do.
The documents that you have.
Do you have another case pending somewhere in the court system other than this one?
It's just this case here. Those were private documents. It wasn't for public only.
Is this something you want to file with the clerk?
No, it wasn't filed with the court. No, it wasn't supposed to file with the court. It was supposed to file with the head clerk, Jessica.
And are you trying to file a case or something other than in this case?
It's referring to this case, yes.
Okay, so yes. We'll upload them into the file and strike them from the record, as I mentioned.
And this is the part, you want to know why she was being evasive when he was asking questions? Because they know it sounds foolish when they speak on it. So they always try to talk around exactly what it was that they filed. You notice that they always talk around it. They won't, or it's documents when they don't ever want to stand up and say, no, I filed this for settlement. Right, whatever.
Before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that have been towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one listens. Everybody's being selective-minded, And I just want to address that to the court. I have so much evidence that I have presented in this court.
Okay, so this is the biggest issue. This is the biggest issue right here. In her mind, she thinks she has valid legal claims. In her mind, what she doesn't understand is that beliefs that a violation has occurred is totally different from proving a violation has occurred under the law. See, she believes everything she's talking about is legit. But when you put it under the legal lens, it amounts to nothing more than googly gop. This is one of the reasons why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
To show you, to prove to you, show facts, and also show you there's a lot of concealment within this court. So I'm asking you, can you address somebody to assist me in that matter?
Ma'am, we appointed the Porter County Public Defender Service, I believe, to represent you. Are you in this matter privately, Mr. Scribble?
No.
So we appointed the Porter County Public Defender Service to represent you, ma'am. I appoint them and then they appoint a lawyer. So you've got Mr. Scribble involved in the case. You can't pick and choose what lawyer you get when you ask the court to appoint counsel for you. You get what you get.
I get that, sir.
Okay.
But only reason why I ask is because I feel like I'm not being helped. I feel like I could do it myself and present this as pro se.
And that's one of the biggest mistakes that they all think. They all think that they're equipped. Like I'm speaking to someone at Telegram and she's following this. She thinks that just because she sees her case one way, oh, I got them. They can't respond. The ledger, they can't find the accounting. And it's getting to the point where I'm like, I see that these are arguments that she has to hang on because I know there's so much at stake with the home. So she has to believe this. It's like they can't not see reality. And it does get to a point where the reality is more unbearable than the belief. So although the belief is going to lead to destruction, they got to hang on that instead of face reality. Because the reality is you're about to lose your home. And I see it headed right off the fiscal cliff. But they never want to accept it. I told you, with court, some of your hardest lessons are going to come when your most valuable assets are on the line. That's when the lesson is going. That's the hard lesson you got to learn. You're going to learn when your house is on the line. You're going to learn when your automobiles is on the line. Because that is the initial time that you are being introduced or have any interest in court, is when those things are on the line. So you're not even fully prepared because you ain't have no interest in this stuff for years before a situation arises where your stuff will have to be on the line. The definition of preparation through and through the case, Thomas versus CAC.
You're rocking with the best.
I'm talking about a flawless execution.
But evidently, it's just being delayed continuously.
Well, if you want me to do what's called a Ferretti hearing and make a determination whether you can represent yourself without counsel, are you prepared to do that?
Yes, I am, sir.
Okay, I mean, I can do that Ferretti hearing, but I'll let Mr. Scribble go for the day, and I'll hold you until we're completed with the rest of our business. I'm not going to make all these other people wait while I go through a Ferretti hearing with you, because it takes a little bit of time.
It does, okay.
And I'm
Is that
asked, Bill,
possible to come back?
What'd you say, Judy? What'd you say?
I said, okay.
So here's a form that I need you to review, and you can step back, and then I'll call you back up here at the end. We can go through the Ferretta with you.
Can I come back?
Come back when?
What time is it? Around 12:30?
Oh, no, ma'am. I don't have time at 12:30, but I have time around 11:30. So, I mean, like I'm saying, you can step back.
Okay.
We will not conclude your matter today. We'll let Mr. Pribble not have to be present for the Ferretta hearing, since it's just regarding whether she can appear pro se, and I can talk with her directly about that. So you can wait until the end of our call and then come back and we can handle this.
Okay.
Judge Fish, please save her from herself.
Okay, all right. Is that all you had, Mr. Pribble?
Yeah, that's all.
Okay, well, I'm glad that you did the heavy lifting. Tierra Butler, we'll go back on the record in 64D01-2306-F6-5582. I have a request for pro se. She would like to represent herself in this matter. So I'd like to conduct a Ferretta hearing. Yeah, I have one here, but I'll use this one. It's fine. Ms. Butler, please raise your hand to be sworn. Do you swear or affirm under penalty of perjury to tell the whole truth and nothing but the truth?
Yes.
Okay, thank you. All right. Ariana, are you under the influence of any alcohol or drugs today?
No.
All right. Yeah, we set a trial already. Your trial set for August 18th and 19th. And you indicated you want to represent yourself. Did you have a chance to review the pro se waiver rights form I presented in open court?
I looked at it a little bit.
AKA, no, Your Honor.
Did you sign off on?
And this is the mindset. She's facing a couple years in prison. But they're not looking at the reality of that. They're looking at, if I can just get my documents through, all this will go away. If I could just get them, the judge, to see what I'm talking about, it'll go away. It's another harsh reality that people have to learn about court, especially open court.
No, I did not sign off on it yet.
Okay, would you like to have more time to review it before you sign it?
Yes. Can I get the second page, please? Because I had written on the back of it. You have it there. I'm just gonna give you a little one. Can I also address something? You just let me know when I can.
Go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it.
See, they all think that the clerk of court is higher than a judge, just like they don't respect no authority but the sheriff. That's part of the sovereign citizen mindset. That's why they think a notary is like the second coming of Christ, when a notary is just validating the identity of the person signing the document. They think the notary is basically saying, yes, he's right. He's true. It's true. No.
May 11, they've been working with me.
See, she thinks that the clerk just doing their job, filing documents. It's their job to stamp it and probably give her information she needs. She's taking that as, oh, they're helping, working with her on getting the account resolved, because they will never be honest with the clerk what they're doing. So they'll present it like it's official legal matter, but they're not really telling what it really involves. So when they'll get to the clerk's window, they'll say something different from what their real intent is.
Providing me all in the county. What you just gotten just now, I think one of your staff did not follow the correct procedures. So,
remember that old Gene Keating Patriot movement? You get an indictment, you sign the indictment, return it back for full settlement and closure of the account, because they all think that court is a bank, like the church is a bank. So I think account. I'm just thinking account, court to bank. So where you can do your transaction. You can close the account. You know what? I never met so many people in this space that always tells other people what they can do, but haven't done it themselves.
I was just want to let you know that my state has not been abandoned.
That's that 1666 Sesti V Act. And years ago, I was like, you know what? They may be onto something here. Until I realized this is a UK law. This is a law from the United Kingdom. It's a foreign law. Has no applicability in the United States.
I also want to let you know that I did not appoint anyone to administrate my state. So, for that being said, I'm coming here with honor, clean hands, and no conflicts. I do not want to argue about anything.
That's I don't give a damn because you're sounding soft and meek and mellow. Who gives a damn? It's still sovereign citizen rhetoric. Why is it that everybody finds about their state when they're in trouble? Or when they need free money? Or when they want to pay for things without the use of real money? Why is it? I've never seen it. Why it's always the same circumstances where everybody finds out about this estate. They never find out about the estate when life is good. It's always when things are not so good that the estate is a big issue now.
I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been excited.
That's what the jury trial's for, okay? All the facts and circumstances related to the case, state's evidence, everything of that nature will come out during the jury trial. So,
AKA court rules and procedure.
I need to go through this Beretta hearing with you, ma'am.
Okay.
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know.
She needs an attorney. And you want to know one thing that I noticed about, especially in trial, what is the most important part? The goddamn jury selections. I mean, me and my attorney was striking the hell out of the jurors. They were striking jurors. They struck a public defender off my jury. Does anybody practice law for? Yes, I'm a public defender I'm a public defender out of Florida. Strike! The government struck her. I said, I knew they was about to strike her. Man, they struck the hell out of her. Has anyone knows anybody that's been a victim of the crimes alleged by the defendant? My aunt was shot and killed in a robbery. Strike! Get your ass up out of here. That jury, the proposed jury instructions is another banger. The reading the jury, knowing who to strike, what not to strike. Hell, before the trial start, the jury selection, that was almost a 3-hour process. Imagine doing all that yourself in federal court. Y'all not equipped. Sorry, y'all not equipped. Y'all understand how it goes. Y'all understand what's those in-between conversations that's going on inside of it. Yeah, y'all understand how it was, especially in federal court. Like, you have to know what you're doing in federal court.
Do you understand that?
I comprehend.
Okay.
See, that comprehend, that's the comprehend I'm talking about. He just said, do you understand it? In her mind, it's a secret trap to make her the surety or something.
And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison.
And this is why the estate comes up. I told y'all, this is why the estate, this is why she's doing what she's doing.
So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
Yeah, that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court.
I comprehend that.
Attorneys have developed certain skills in investigating your case, interrogating witnesses, and finding favorable witnesses and obtaining their testimony. They can explain the charges and any lesser known and included or lesser included offenses to you. They can gather documents and other kinds of written evidence. They can prepare and file motions before trial, such as motions for a speedy trial, motions for discovery, motions to keep unfavorable information from being received as evidence. They know how to examine and cross-examine witnesses at trial. They can recognize objectionable and unfavorable evidence and promptly object to its use.
Everything he just said, less than 1% of pro se litigants in this space understands that part of court. Less than 1%. And these are the things that anyone that calls themselves pro se in court needs to know. This is why 98% of people should not be going into court on their own.
They can present favorable sentencing information and attack unfavorable sentencing information at a jury trial. They can present favorable opening and closing statements, prepare appropriate written jury instructions, and select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal.
What did he just say? Look at what he just said. I want y'all to pay attention.
Prepare appropriate written jury instructions and select a jury. Motions to keep unfavorable information from being received. Interrogating
all that.
Witnesses and finding favorable witnesses and obtaining their testimony.
Right here. This is exactly what I was just talking about.
They can explain the charges and any lesser known and included or lesser included offenses to you. They can gather documents and other kinds of written evidence. They can prepare and file motions before trial.
Right there. Those in-between motions. Those in-between ones.
Such as motions for a speedy trial, motions for discovery, motions to keep unfavorable information from being received as evidence.
All those in-betweens.
They know how to examine and cross-examine witnesses at trial.
One of the most important things that you have to know if you want to be pro se.
They can recognize objectionable and unfavorable evidence.
Right there. Off the break, you got to have an eye for it.
Promptly object to its use. They can present favorable sentencing information and attack unfavorable sentencing information at a jury trial. They can present favorable opening and closing statements, prepare appropriate written jury instructions.
Right there. That is the one of the most important parts, the goddamn jury instructions. You better know how to write. I think I'm going to post my proposed jury instructions in my case, just in case it went to trial. Oh, I had the motion for you thought the lawsuit was something. I already had the whole case already typed up. Here's the discovery. These are all the issues where they're probably going to BS me. So let me go ahead and type up my motion to compel discovery, show cause. That was done. My proposed jury instructions, my open and closing statements were done, which I rehearsed for, what was the last 4 months, rehearsing it. Damn near memorized it all by hand. Held mock trials. Oh, nah. It's just, many people think pro se court is just an extension of the administrative game. Because everybody's banking on the case being dismissed without ever having to appear in open court. See, it's one thing where you're just going over the rules and procedures and statutes and responding to motions back and forth. It's another thing actually being inside open court It's a different ball game inside the open court, especially on the federal level. Oh, your little violations of speedy trial, you ain't got to worry about that. Federal courts is a rocket docket. You get indicted in January, you have your shit by March, trial started. You get indicted January, by March, your ass is in trial. You ain't got to worry about this speedy. That's one thing the federal courts don't play about. The government don't play about. Your ass is going to trial inside of that 90 days. You don't even think about it. Oh, let me see if they don't even worry about it. Like, oh, it's getting that. Nope. This is why you only see they talk about this stuff in state court. This is the only time you see these people. Federal courts, it's a totally different ball game. They're not winning like that in federal court. They're not winning like that. They ain't winning like that. They're not getting, you don't see this shit every day. Free and clear title to your shit. Making them, man, you pay the rest of the $21,000. You pay it. Waive that bitch. You don't see that every day. You don't. You don't see my outcome every day in these spaces. You don't. You haven't. I'm still waiting for these titles everybody be talking about from a legal, not no title washing scam. I'm still waiting for it. They say, you ain't really do nothing. I still don't see no titles.
And select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal.
Why do you think preserving the records of the case for the purpose of appeal? Why do you think he said that? Because there are no guaranteed 100% wins that you're going to win in court, regardless of the facts of how strengthened your case is. So every lawyer prepares to preserve the record just in case you got to go on appeal. Not in these spaces. File, respond, win. Everybody, if you come to me, we file or we respond, then we win. That's pretty much what they tell people. And that's not the reality. Nobody, and I'm talking about a minimum of at least, I'm going to say about 40 cases. Minimum. I ain't talking about you just started off and you had a credit card template. I'm talking about you've been around this shit for years. You're going to know what it's like. Nobody is ever going to win them all. Nobody. You got the best lawyers that will mop the floor with all of us put together in court. Litigants, true trial attorneys, recognized by the state, won big awards. They suffered defeats. So you mean to tell me in these pro se spaces, nobody's ever lost? Ever throughout their whole career? I don't believe, none of you, I don't believe it.
Prepare appropriate written jury instructions and select a jury.
I'm talking minimum. You've been around for a minute. I ain't talking about just starting out. I'm talking about you've been around for a while.
They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay. You must understand that if you decide not to have an attorney, you will not.
See, in her mind, she's not worried about none of that. She thinks those private documents is going to get the case over. So she's not even going to be worried about preparing for any of that. This is where she's walking herself off the fiscal cliff. In her mind, she don't need to worry about all that because those private documents is going to get the case over.
Receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an office of executor observations, findings regarding Porter County Superior Court interaction.
What this is now the goddamn third different case. And what do they have in it? The executor. What do you see online? The executor. Told you. It's a MH crisis.
With Tierra Lene Butler. You talk about final order to settle and close, different things like this. And then there's like
that's that Gene Keating early patriot movement, settlement and closure of the account. Send the indictment back for settlement and closure. That's all it is.
Recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research.
It all starts there. Right there. It all starts there. It all starts there. I did some research. Red flag. In these spaces, red flag. As soon as I hear someone say, oh, I did some research. I did some research. Red flag. AKA what they're saying is, I followed this. I jumped on the sovereign citizen bandwagon because their research is biased, confirmation biased at that. It's from a document that you can find on Scrib, flooded with misinterpreted statutes and case laws. All cases are going to be at least 100 years old. And the cases that they do cite from the 20th century, the elements of that case has nothing to do with theirs. Oh, yeah. That I did my research. Buzzword, red flag. I know what it means.
On my case. And I noticed that
that's not the question.
My case.
Processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that
that's not the question I asked. I think you misunderstood the question.
It's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand that?
Yes, I am in a criminal proceeding, but like I've been trying to explain ever since when I had.
Well, I need you to answer the question I asked you. Okay, which was whether you understand that these documents and things that you follow at the clerk's office. What's the receipt date on this?
It should be April 16 or 15.
April 16th it was received, so just yesterday. That these aren't criminal matters that you followed with the court?
Those aren't criminal matters, the violations that have been held against me. Yes, that's a lot of violations.
You understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
There you have it. There you have it. What did I say?
You're rocking with the best.
What did I say? Belief systems over reality. She thinks those are violations. The judge is saying none of this we recognize in the criminal courts. None of it. This is where the beliefs run smack into the reality. And this is the fate of 98% of people in these spaces. They all think they know what they're talking about. They know what they're doing. The law works a certain way because they believe it does.
Well, you're saying what I just found is not what? Criminal?
This
explain a little bit clearer.
These papers seem to indicate that you're trying to proceed in equity or sort of a pseudo legal jargon, some type of a.
Is we in Article 4.3 right now?
There we go, right there. I just had a live on this about 2-3 weeks ago. Proceed in equity. Oh, I move in equity. Anytime I hear someone says I move in equity in court, red flag. red flag, because they think equity is some, oh, I don't got to go through the court rules. I don't got to go through the court rules of procedure, rules of evidence, hearsay. I don't got to do none of that. I just sign it and send it back and get it closed. See, that's what they think equity. They're not talking about the principles of fairness and justice, equitable resolution. No. They're talking about some secret trapdoor to the courts where all you got to do is be the select few that knows. You know, nobody else knows this. Well, how do you know it if it's supposed to be a secret? Because people 40 years before you've been saying the same thing. So why are you saying nobody else knows this but you? We're not clearly looking at your documents, and I can point to you from the origins of those documents. Not so much of a secret now. I know the grandiose, you want to make yourself feel bigger than what you really are. I know, just pop that air bubble. I know. And this is Article 3. Once again, Article 3 only pertains to the federal courts. And Article 3, federal courts are courts of limited jurisdiction, meaning has to be real cases or controversies governed under federal laws. There's nothing federal about this proceeding. So she's using that Article 3 incorrectly. Ellis Raspberry, aka Equal Footing, watch my Article 3 video, because as soon as he went live again, when I was supposed to go on this panel and debate him, he switched it up from a Article 3 to a Article 1. He didn't talk about Article 3 since. After I put that video out. Let's talk about Article 3 jurisdiction. I mean Article 1. No, why you switching it up now? Because now you're talking about tax courts. Now child support is somehow a tax court. See, you got to see with these people, they got to switch their foundation up every week. They can't, their foundations are weak because they always got to try a new process. It's always, they got to learn something very new. When you have a real foundation, your foundation applies across multiple different venues. This is how you know you got a solid foundation, where the underlying merits and your underlying, substance of your foundation, it will be applicable in state court, federal court, if it was the tax court, bankruptcy court, applicable in accounting standards, insurance, corporate transactions, commercial transactions, consumer transactions.
You're rocking with the best.
Same elements, just a different venue, different situation. Core elements are still going to be applicable. Oh, I forgot one. Student loans.
Say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This
Means
is
that
court of Porter County.
Okay, so we basically still in the same court as administrator. So you basically trying to administrate a mistake. But I was letting you know.
Okay, Ms. Butler, you understand that these administrative things that you're talking about aren't part of this court proceeding?
I know, I'm aware of that. I was talking to myself. But what I'm saying is, I have done some research.
Red flag.
Okay, and I actually,
you notice how you can have so many people with so many different minds, so many different ways of thinking, and they all do the same research? Like, don't none of y'all ever do any different research? It's like y'all all research the same things.
Wanted to address it, and I'm not getting no assistance with the public defender. Okay.
What are you trying to address, ma'am?
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when the what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents, the evidence held against me, and he refused to present them to me. That's a branding violation because it worked in my favor when I first got it. Then also on the record,
I'm trying to get you through this Feretta hearing.
I know, but you asked me, and I'm trying to explain the.
It's coming out now. It's coming out of her now. The sovereign citizen's coming out now.
Violations, okay?
Right, but those aren't violations that are part of this court proceeding.
Now,
there you go. This is the classic example of this live. Violations to them are violations when they feel like they've been violated. But when you put their allegations under the legal lens, they're not violations that are recognizable at law. That's the difference. And no, it ain't because it's conspiracy. The judges, no, we got to move off that. Maybe you don't have the violations are only inside of your head. Maybe the reality is only inside of your head, because the realities of the real world is not comportant to what's inside of your head. Maybe it's all in your head.
This court
if you have something that you plan to file related to that, it has to be filed through your attorney. You can still have an attorney.
I did that too. You know what he did?
I don't know, man.
Ignored me.
What?
Right, because he can't put that garbage. Just because you have an attorney doesn't mean you could just give them anything to file. They got rules and standards and codes of ethics that they got to follow. They're not going to get sanctioned because of you, because you want to put your sovereign citizen records. Yeah, he may lose his job. He may get sanctioned. I wouldn't put that crap on the record either. You're going to have me looking crazy in front of my colleagues, making a mockery of the court. See, they get in trouble. Y'all don't get in trouble for doing it. They get in, well, some of y'all get sanctioned, but they get in trouble.
You have filed through the clerk's office, you're saying that matters in equity. We don't recognize what you're talking about in these filings.
This is a bank. This is a bank. I understand how.
What'd you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This court system doesn't operate like a bank in any way whatsoever.
Hold on, let me finish.
No. I'm not going to let you finish that particular statement.
I said I want to don't want to argue.
I need you to.
I just want you to understand me mentally.
Oh no, we understand, and we understand that you need help.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things.
Welcome, Judge, to 99% of pro se beliefs about
You're rocking with the best.
If you don't want to hear from me, when I say they're not equity, they're not banks, none of that stuff y'all talking about on this panel has any legal basis in law or fact. And they all got mad and want to jump on me on the panel. Well, if you don't want to hear from me, what do I always say? I'll let the judge tell you.
You're rocking with the best.
You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know.
Well, what do you know? Oh, now I understand why Equal Footing got up off that Article 3. Yeah.
In the state of Indiana, separate judicial branch.
Yes.
Not any of the things that you've said here.
Yes.
So what I need you to tell me is whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana.
Your Honor, please deny the Feretta and keep the attorney on the case. please save her from herself.
You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes, yes,
You
yes.
will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding.
Rule 12F, anything, filings, pleadings, and motions that are filed that are impertinent to the matters at hand shall be stricken. So that's why under trial rule 12F is being stricken. So these are the things that you got to understand. Okay. You got to understand the general court rules of procedure, the procedures that the rules that govern the procedures. Then you got your rules of evidence. Then in the federal court, you got each jurisdiction's local rules. Then you got the trial rules. Then you got the appellate rules. Thousands and thousands and thousands and thousands of pages of court rules and procedures that you have to be aware of. This is why many people do the administrative route. This is why many people say you ain't got to go to court, do that. It's not because you don't have to. It's because they know it's too confusing for them. See, those people, even though they don't want to admit it, they understand their own limits. Court is not for everybody because you got to know so many things. And even knowing those things, it's not going to prepare you for the nuances of court. You're only prepared for the nuances of court of years of being inside of it. Experience. You think court just about you just filing motions back and forth and you just sit back in the comfort of your laptop and just file motions back and forth. There's going to be a time where you're going to be in open court and you're going to have to stand on everything that you're putting on the record.
You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a minute.
Okay, so she thinks that she filed it on the private side. Once again, has no legal basis. And even if you filed something, and I assume she meant to go straight to judge's chambers, you cannot unilaterally have or make or submit private communications to the judge. Because as soon as you do it, they're going to make a copy and send the other side the copy. Both sides has a right to know what's being filed, what's being communicated. Because if they was doing it against you, Brady violated my rights. See, one thing that I notice about these pro se spaces, they're so focused about their rights not being violated, but they want the courts to bend the rules and stretch the rules for them so the other side's rights being violated. They don't look at equity as being a balancing scale. Both sides, 50% equity. That when people in pro se spaces look at equity, they think equity is I just get everything I want with disregard for anybody else. That's their definition of equity.
What's the name of the clerk's office?
The clerk's office is the clerk of clerks. Clerk of clerks.
Clerk of courts, right? So there are
no caps. No caps. That's a fact. That's a fact. No caps.
Are clerks. So if you file something and you have a case pending, they send that to your case. Unless you try to open a case of your own.
No.
You're trying to open litigation of your own?
No. What I am.
This has to be presented in your court case here. You have pending before us.
Okay, so this is a very simple concept to understand. If you put it on the court records, it's going to be part of your case file. The judge is going to see it. You can go online and see it. It's nothing private about it. What is this private crap you're talking about? Oh, there's a public and I told y'all. And the public and private side, that's like damn near 30 years old. That rhetoric is about damn near 3 decades old.
So you will not strike it?
Rules.
You won't strike it down or you will strike it?
Oh, it has to be stricken. It is impertinent to anything we're doing here. You understand?
So basically, all your research amounted to nothing because those documents are a byproduct of her research. Meaning, I found a group or a social media guru to put those documents together for me. That's all it means. So that means everything you spent your money on, or the rabbit holes you was going down, everything that comprises of your newfound belief has been wrong. That's what it means. You're wrong.
Dan?
No, I don't understand.
Okay.
Now the reason why she's saying she don't understand, because now the reality is slapping her beliefs right in the face. And they can't fathom that they're wrong with their beliefs. This is all this is right here.
You have filed documents making commercial demands, demanding accountings.
Yes.
Challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity answer to,
and for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
Okay.
You realize that?
What's the theme of this live stream? Belief system versus belief systems about courts versus the realities of court. Who wins?
But let me explain. Can I make a statement to you then? You said there's no basis in criminal.
Go ahead. What's your statement?
Well, I also want to say something. And also I am a minister. And I want to read this on.
And this is when all else fails, they try to pull on the court's heartstring by quoting Bible verses and get religious in court. This is a classic. This is the classic thing. Whenever they want an emotional ruling in their favor, they'll manipulate the Bible. These people, there is nothing. Now, she's a minister. I told you, in these spaces, you can be whatever you want, whenever you need to be it. But there's no depths that they will go to exploit in order for them to get the favorable outcome. Now it's Bible verses in court. How many times have we seen that?
On the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executor. As such, this office gives notice of its accusations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15.
And everything you just said, ma'am, amounted to a bunch of googly gop. It's not getting you out of the charges. It means nothing in court. On a spiritual, on a Sunday morning from 9 to 11, I'm with you all day, ma'am. But on a weekday inside of a criminal court, it means nothing. Do you know how many people read 15 pages out the Bible before they was handed down a 35-year sentence?
Like I said, I came here with clean hands. And I'm now the executor. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it.
But these estates are never claimed when life is going good. These estates are never claimed when they're not in foreclosure. These estates are never claimed when they're not facing repossession. These estates are never claimed when they're swiping the credit card and receiving the benefits and the value for the use of the card. When they're turning the keys into their home. When they're getting behind the wheel of the vehicle they just financed. You notice that the estates are nowhere to be found. The estates are nowhere to be found.
I discovered a lot of things along the way, putting me in this position.
Okay, ma'am. Clean hands is an equitable doctrine. You understand that? This is not a court of equity. If you were in a court of equity, you wouldn't even be given or afforded the right to a jury. I think it's appropriate for me at this time now to terminate the Ferretta inquiry, deny your request to proceed pro se.
Thank you, Judge. Thank you. Thank you, Judge. Thank you.
You're rocking with the best.
Thank you, Judge. You just saved her from herself. Thank you. Thank you.
I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings of the defendants utilizing rhetoric of what would typically be called a sovereign citizen movement, including raising nonsensical on the rule. The right of self, including raising nonsensical genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings of the defendants utilizing rhetoric of what would typically be called a sovereign citizen movement, including raising nonsensical challenges and attempting to apply commercial law to criminal prosecution.
There you go. And guess what? He's reading that from his computer screen, so he already had it ready, pulled up. They already have these things ready for him. He's reading from the screen because they've seen it for so many years. They have a standard response to these Ferretti hearings. Because in court, when people normally want to fire their attorney and represent themselves, it's normally done by sovereign citizens.
You're rocking with the best.
Yes, it's normally done by them.
Or equitable law.
No, that's
man, you keep saying no, but you're talking over me, and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law based on the defendant's filings and her statements in open court.
Relevant rules of procedures and substantive law. The things that I preach day in and day out.
Court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied, and appointed counsel will remain on the case. We're adjourned. Okay, are you prepared for the suppression hearing?
I am, Your Honor, yes.
All right. How would you like to proceed?
All right, this is a suppression hearing regarding her.
All right, it's defendant's motion, so I...
It is their motion, but often the state would go and present evidence related to the motion. Have you reviewed the motion to suppress?
Have, Your Honor, yes, I'm ready to proceed. I'll call my first witness.
Do you believe it's the defense burden on this one?
I believe so, but...
Let me look at it. Ms. Butler, what's your position on the motion to suppress? You feel like you need to present evidence, or should the state present evidence to show that the statement that they are relying upon is a viable one?
How do I present?
Hey, shut up! Don't say nothing. The judge just threw you an alley-oop. No, Your Honor. I believe the prosecutor. The judge just threw you an alley-oop. That's why he asked you, what's your position on it? He's throwing you. Don't say nothing. Make them prove it right now. This is what I mean. Being in court, understanding the tones and the words of judges, reading the context clues, reading between the lines, and a dime picking it up. I would have went in there with my ready to defend, and as soon as I heard the judge say that, I'd have set it to the side. Your Honor, I think the position is that they should be able to, prove it. He just threw you an alley-oop.
To suppress?
Have, Your Honor, yes, I'm ready to proceed.
Look at the question.
I am, Your Honor, yes.
All right. How would you like to proceed?
All right, it's defendant's motion, so I...
It is their motion, but often the state would go and present evidence related to the motion.
Right there. I would have slid my statement right up under the folder. It's uh-oh. I see what's going on here. The judge really wants them to go first. Well, I'm going to make them go first. I see what's going on. See, listen, in court, you may have a whole script. You may have to abandon that whole script after the first two sentences because the way courts goes. I just went through this in the last hearing in June. We had a whole script. We got through probably not even the first page. I said, throw that script to the side. We plan the rest of this hearing by ear. We're going to freestyle the rest of this hearing. Had a whole script ready to go. Throw it to the side. because I seen where the case was heading. The case is heading in this direction. We're staying right here. And none of what we were staying right there was part of the script. Came up with defenses as we went. As I kept hearing what's going on, came up with defenses as we went. Ah, come on, man. If anybody think, no, you didn't, the video's already been posted.
You're rocking with the best.
Good God almighty, he threw you an alley-oop, girl.
Have you reviewed the motion to suppress?
Your Honor, yes, I'm ready to proceed. I'll call my first witness.
Do you believe it's the defense burden on this one?
I believe so, but
Let me look at it. Ms. Butler, what's your position on the motion to suppress? You feel like you need to present evidence, or should the state present evidence to show that the statement that they are relying upon is a viable one?
I would like
right there. I would have used his words. Your Honor, I think the state should show that the statement that they're relying upon is a viable one. I would have just took his words and threw it right back to the court. Situational awareness. These are the things that you have to pick up quick in court. You have to pick up quick in court, fast. It's not even like you gotta be looking out for these things. Most per se litigants, they so buried on what they want to read and talk. They're not even, they don't see nobody else in the court but them and their arguments. Like, you gotta look around, you gotta see what's going on. Obviously, the prosecutor don't want to go first. And the judge is like, I think y'all should go first. Read the room. No, not with pro se litigants.
Present the evidence.
You want to? You want to present evidence first?
I will follow whatever you just.
No, he's trying to. No, just say it. That's why he's saying you want to present evidence first. The burden's not. The burden's not on you right now, girl. This is one thing I'm glad that she did that though. I'm gonna follow whatever. I'm glad it looks like she's starting to pick up, and this is the court's way of helping pro se litigants. Because if that was an attorney, the attorney would have threw the burden back on the prosecutor. But these are the subtle ways that I see every day online, how the courts help pro se litigants with these in-between interactions in court. This is what I mean. Open court is a different ball game than just filing motions back and forth.
Okay, so I don't want to jump ahead. So you tell me what you would like from me.
Yes, Dave, I think you should go first on this.
What did I tell you? What did I tell you? What did I tell you?
You're rocking with the best.
What did I tell you?
You're rocking with the best.
I just told you, read the judge's clues. Make them go first.
You're rocking with the best.
What did I just tell you? I read that shit. I read it. Now I make them go. I read the whole run. I said, y'all go first. See how the prosecutor looking? When the judge says, you sure you want to go first? The judge is saying, no, don't go first. Anytime a judge says, are you sure? You sure you don't want to put nothing on the record? You sure you don't want to say that? He looked at her like, you sure you want to go first? Basically saying, don't go first. He can only, they have their subtle ways of helping you navigate through court. I'm telling you, pro se, they got their subtle ways of, judges have their subtle ways of saying things to you in court, but you got to be in court. Listen, it may not be as easy from a person that spent 22 and a half years inside of courts. These are the things that I just naturally see. Like I will naturally spot out in court.
The motion to suppress, you feel like you need to present evidence, or should the state present evidence to show that the statement that they are relying upon is viable one.
I like this.
Right there. The judge sees that there's, I don't know about this. The judge, I'm looking at it. I don't know about this statement here. I'm just, I don't think you, I don't know.
Present the evidence.
You want to?
Right. Yeah. He looked when she was like, she got her phone out. I didn't want to present the evidence. He looked at her like, you want to? Basically, like, no. YouTube, look at his face. Look at his face. Look at his face. He's like, no, don't. Shut up. Don't say nothing right now. Look at his face. Like, he looked up like, you want to? Man, everybody in the room, read the courtroom. Read the damn room. Sometimes reading the temperatures of the room as pro se will help you navigate through court just by reading the room, knowing when to get in, knowing when to slide your evidence in, knowing when to shut up, wait for the judge's response, gauge how the judge feels about an argument. Sometimes you don't have to say nothing. If the judge gets to questioning them too much, you don't say nothing. And when it gets back to you, read the room, slide your 2 cents in, get the hell back out the way, object with you. It's a bunch of things that you got to be aware of at the same time in court. This is where these people go to school for. I'm only telling you what professional attorneys told me. That's how it goes. Like, you got to read, you got a situational awareness.
You want to present evidence first?
I will follow whatever you just lead me, okay? So,
but you know what? In 2020 hindsight, I think that was a perfect answer for her based on her understanding in the moment. I think that was the best thing she could have did. Because many pro se litigants were so quick to just read what they have on the record, not knowing you don't really have to prove shit. You filed a motion to suppress. They gotta say, nah, this is legit. So just let them go first and prove. Pro se, they always want to just be in the forefront of everything.
I don't want to jump ahead. So you tell me what you would like from me.
Yes, Dave, I think you should go first on this. Yeah.
Okay. I'm ready for my first one, Mr. Honor.
Sure. Want to have him come up?
And were you assigned to investigate a matter involving the defendant in this matter?
Yes, I was.
And
now, whether it be suppressed or not, now we at this stage right now.
And do you see the defendant here in the courtroom today?
Yes, I do.
Can you please point out where she's sitting?
She's sitting at the table directly in front of me.
And who is the defendant?
Tiara Butler.
Can you please let the record reflect that the witness has identified the defendant?
So noted.
Can you walk the court through why you were investigating the defendant?
I was contacted and received information from one of our analysts from our headquarters regarding suspicious fraudulent transactions that were being conducted by Ms. Butler based on data that he was reviewing.
Based on data he was reviewing. I received a contact or alert from one of our analysts based on fraudulent transactions, based on data he was reviewing. Now, that man in the back may be that person, but as a preliminary, I just would have objected to hearsay on a just to do it, because you never know. Don't leave no stones unturned. I don't give a damn if the judge sustained it or overruled it or not. Just because they made something that come up later that at least have the record preserved on appeal. These are the things that you got to think about in court too. Always thinking about appeal, preserving the record. You may not win every objection. You're just preserving the record. These are all the things you got to think about in court.
In response to that, I installed cameras into the facility to record her during the transaction time. And during a period of, I believe it was May of 2022 through January of 2023, I located approximately 20 transactions that she had conducted with no customer present, which were for cash refunds and other things. And so the next part of my investigation was to conduct an interview of Ms. Butler.
And when you say you place cameras in the facility, where What facility are we talking about?
This is the Valparaiso downtown post office.
Is that located in Porter County?
Yes, it is. Miss Butler was asked if she'd be willing to answer some questions, and she agreed. So then we set up an area inside the post office where we were going to conduct an interview of her.
And then did you conduct an interview with Miss Butler?
Yes, I did.
And
if I was in court with that, I'd be looking at them like a hawk. I'm just waiting. I'm just waiting right now. I'm waiting. I'm waiting to hear something.
Can you describe to the court what did you first do in the interview?
Well, first thing we did, like I said, we got the room set up. We had chairs and positions so that the three of us could sit down. The first thing I did is presented her with what we refer to as our Garrity form. And it's basically an acknowledgement of rights form that we present to employees that are not in custody. And I went through that form with Miss Butler, presented it to her. She read through it. Once she completed and signed the form, and we.
Okay, so basically, this is not an average detective, and I'm trying to figure out just about the post office. I mean, I know post office is usually concurrent jurisdiction, but she's lucky this is not a federal court right now.
Witnessed it. I confirmed with her verbally that made sure she understood the rights that were explained that she had placed her initials next to when she was completing it, and she stated she did.
Okay. And did you also sign that form?
Yes, I did.
And then did Agent Klemick also sign that form?
Yes, he did.
Agent, so if I'm handing you what's marked as States Exhibit 1, do you recognize that?
I do.
And what is it?
This is the Garrity Acknowledgement of Rights form for employees not in custody that was presented and completed by Ms. Butler.
And is that a true and accurate copy of a waiver of rights form that Ms. Butler signed?
It is.
Your Honor, it would move to admit States Exhibit 1.
Any objection, ma'am?
Yes, I do object.
What's the objection?
The object that it was given towards the end of my statement because I had to sign, because I had the pen at the time. Because at the beginning I didn't have the pen. I had the pen at the time, and I did sign. But how you know that he signed it later is because look at the times at the end. It's at 10 o'clock. It's in his penmanship.
So your objection is related to authenticity or?
It was towards the end of the statement, when I was writing the statement. That's when I was given that one. I wasn't.
Evidentiary rule is your objection?
Okay, I was just explaining that.
I'm asking you,
Yes.
what's your basis for your objection? What's the evidence?
My objection that he did not give it to me at the.
Evidentiary, girl. It's basically you're trying to object it being admitted into evidence based on, I guess, wasn't signed in the presence of you. It could have been altered, something.
Beginning, he gave it to me towards the end.
I think it goes to authenticity or something, but it's
right.
Overruled.
Right. I feel you, Judge, because I was trying to find something for her too. I'm like, no, I ain't surprised by that one because I was looking for. It's not like he took it home with him. It's not like you never even got one. It's not like you didn't sign it. It's not like they never produced one for you. That, like, yeah, but you already made, towards the end, towards the beginning, they probably had a conversation with you about it. So, yeah, it's nothing.
And there are 4 paragraphs, I would say, listed 1 through 4, correct?
Yes.
Okay. And beside each of those paragraphs, Ms. Butler did initial.
That is correct.
What does the first one say?
It says, I have the right to remain silent if my answers may tend to incriminate me.
And number 2?
Anything I say or do may be used as evidence against me in a court of law and in other proceedings, including administrative proceedings.
And number 3?
If I refuse to answer questions because my answers may tend to incriminate me, I will not be disciplined solely for remaining silent.
Don't, if you know you've been doing dirt, when they come to interview you, you know why they're coming. Don't say nothing and ask for an attorney.
And number 4.
This interview is strictly voluntary, and I may leave or stop answering questions at any time.
And again, that is signed by yourself,
Yes,
and it is also signed by Ms. Butler,
yes,
and it is also signed by Agent Klimick.
yes.
And what was the defendant's demeanor like throughout the interview?
She was
Objection, relevance. Objection, Your Honor, relevance.
appeared to be nervous.
Objection, Your Honor, relevance. Nervous is not an indication of guilt, of no relevance. Objection, Your Honor.
Her mouth was dry at times.
Objection, Your Honor.
When she was speaking with us, it was.
Your Honor, objection. My demeanor has nothing to do with the proceedings of my motion to suppress.
A challenge to try to keep her focused on what I was specifically asking.
Yeah. Would any of you else would have objected when she started asking me how was the demeanor? I would have objected.
She tended to segue off into other things, but she was responsive to the questions.
And after Ms. Butler signed her acknowledgement of rights form, what then happened?
I conducted the interview, asked her the questions that I wanted to ask regarding the transactions that were captured on video. She explained certain things that other employees were stealing from her drawer and her unit reserve. She explained that she was having severe financial hardships at the time when she was assigned to that office. Her car was repossessed.
Objection, Your Honor. And I know the other side is going to say laying the foundation. I still would object. I still would object. If I was there to objection, Your Honor. Because I know the other side would say, see, you always got to anticipate the other side. It does, Your Honor. It shows the possibility. It shows the intent. Objection, Your Honor. No, Your Honor, intent. And they probably would have won on the intent. But I still would have objected. That's one thing my federal lawyer did. Object anything that starts to paint you in the bad light or starts to slide outside the scope of what you hear, or if it's like leading the witness and all that. Oh my gosh. Shout out to Denise Tassie, boy. I learned a lot from her.
You're rocking with the best.
40 years as a federal and state lawyer.
When she got it back, her interest rates were increased, her loan doubled. And she just kept
because it shows intent. It shows intent. Object.
explaining things like that.
And was Ms. Butler given the opportunity to write out a statement?
At the end of the interview, correct, we offered her the opportunity to write out a voluntary written statement. It wasn't mandatory, wasn't required. And she agreed and chose to write one.
And she wrote a statement?
She did.
And did she sign that statement?
Yes, she did.
And did you ever make any promises to Ms. Butler?
No, I did not.
Object.
What's your objection?
The reason I object is because he would not accept my statement.
Oh, okay. So it doesn't sound to me like
That's not a legal objection. It's not a legal objection. Let me go back what he said first.
And did you ever make any promises to Ms. Butler?
No, I did not.
Object.
There's nothing to object there.
What's your objection?
The reason I object is because he would not accept my statement.
Okay. So it doesn't sound to me like you're having an objection, Ms. Butler.
Right, I said there's nothing. I just said it. There's nothing to object there.
What it sounds to me like is you're about to try to engage in
Testifying and stuff. Yep. It's a typical pro se litigants that don't understand how this part of the proceedings go.
cross-examination.
No.
Yes, ma'am. Make sure you understand the order of proceedings, okay? She's going to ask him questions. In the course of that time, you may have objections to certain evidence.
Yes.
Those evidentiary objections must be based upon evidentiary rules. What you attempted to do a few seconds ago is start to say your side of the story or to question or ask about certain facts that you disagree with.
100% classic example of what she was doing. You are 100% on point, Judge. 1000%. But this is what 98% of pro se litigants do anyway, what she did. As soon as they hear something they don't want to hear, they want to start testifying. They want to start signifying and testifying.
And that's my job, is to make a determination about whether or not the agent's telling the truth or not.
Okay.
And your job when you question him is to bring up the thing you just wanted to object about in a question form to him. Do you understand?
Yes.
Okay, so you've just got to work with how we do our process.
Yeah.
Okay. And this objection, I'm not sure what your grounds would have been, but I will overrule that objection and counsel may proceed for the state.
Agent Soko, there were no promises or inducements offered to Ms. Butler for writing out her statement.
No. The statement was completely voluntary. She didn't have to write it if she didn't want to.
And did Ms. Butler ever ask to leave the interview?
No, there was periods during the interview where she asked to get some documents that she was wanted to present to me. And she got up and she went and got the documents from the other room. She came back, she presented them to me. But other than that, she never requested to leave or end the interview.
Did Ms. Butler ever ask to rewrite her statement?
No.
Again, ma'am, I heard you say object, but it doesn't sound like it's an objection.
It's not a legal objection. It's not.
It sounds like your proper cross-examination of this witness, okay? So hopefully you're noting down the things that we're talking about here so you can ask those questions of this witness.
And she's not taking notes. You're supposed to be there taking notes about what he said. You're supposed to be, this is what I'm saying. This is why people are not prepared to be inside of open court, trial, witness, evidentiary hearings. They're just not prepared in these spaces.
So Agent Seago again, Ms. Butler.
And the reality is, it's not unsurprising unless you went to school for it. This is why lawyers go to school for times like this. So if you're not putting in the same amount of work as a lawyer would do at law school, you can't just think that you could just cut corners in court, that you could just go to court and do your way of court. It don't work like that.
Butler was free to leave this interview at any time.
Yes.
I have no further questions.
Good afternoon. Good evening. On February 1st.
And stop with all the theatrics and the Lord Heavenly Father. It's just stop.
Is it true when I asked you, who are you? And you stated that you was an interviewer and that you was only coming there just to interview all employees just to see how things are. You don't have no control of firing or doing anything in that matter. Is that true or false?
The statement is not completely true.
As Grace say, that was a good question. That was a good question because I see where she's going. Because if he's presented like I'm just an interviewer going to ask some questions versus I'm an investigator, you get what I'm saying? But you still signed the statement and went and had the interview. But I get that. I mean, as far as where you at, I give you that one, I guess.
I advised you that I was with the Inspector General's office. Yes, I did, and I
Oh, okay. Nah, it makes sense now. Never mind. It makes sense.
showed you my credentials.
No, you did not. That's a lie. That's not true.
Okay, ma'am, and what we're doing there, that is called argument, okay? So you want to take those notes down. At the end of this, there's going to be the opportunity for you to tell me the reason why you think I should rule in your favor. And one of those would be that you think he's given a dishonest response to your questions, okay? So that's the order of proceedings. I see you're getting emotional.
Ma'am, crying doesn't help you in court. Crying, emotions, getting mad doesn't help you in court.
If you need a moment, we can take a moment.
As I say, people don't have the emotional stability to be inside of a courtroom. They don't. All that still. Ooh, Lord Jesus. Stop it.
The next question. When we sat down.
Amendment, you're going to be able to talk about whatever you want to talk about.
Thank you.
But you still have a Fifth Amendment issue that you need to be fully aware of.
Yes.
You say incriminating things. The state's going to get the chance to cross-examine you. They're going to have to cross-examine you in what we call the scope of whatever you testify about during your direct. But anything you say can be used at trial for what we call impeachment. So if you change whatever testimony at trial that you might give today, they'll be able to use whatever you said today and say that you said something different today.
And that's one of the things that you have to be aware of too in court. Going back to hearings, three dates before the trial and pulling out the evidence from there. I'm telling you, this is a very different ball game preparing for fucking trial.
I get what
you understand all that?
I'm following you.
Okay, so I just want to make sure you're aware of what you're doing. Please raise your hand to be sworn. You just swear or affirm under.
And 5106 is where we're going to stop off. I have to run. I got to take care of some things. But that was a good one. That was a good one today. That was a good one. Next time we come back, we're going to finish this evidentiary hearing, or what is it? Motion to suppress hearing. We're going to finish it because I'm curious. I'm pretty sure we can all learn a lot from what's going on in this hearing. The judge has been very insightful as well, just for those who's listening, want to get pointers and stuff. But yeah, y'all, it's a very very tricky thing in court. It's very nuancey, very tedious, very intricate. The rules of evidence, trial rules, presenting documents, the form and formatting, laying a proper foundation before you admit to exhibits into evidence, all of that stuff. I've only got abreast of that stuff because I spent 22 and a half years in court, and I've seen my lawyers do it left and right. And I was stayed in the law libraries and going back in front of court. So I actually had in-court experience to go along with just learning the court rules and procedures and trial, how the trial goes. I've actually sat through a trial, a federal trial at that. So I know how those things go. I know how the whole proceedings go, the in-between motions, these and that, jury instructions, all that. So it's very tedious. I don't recommend anybody that comes directly from these spaces to start trying to fight their own stuff in court, because these spaces, they don't really prepare people for the realities of court. They prepare people for the hopes and the dreams and the 2 victories a person got in the span of 6 years, and everybody just gives you the easy stripped down version. All you gotta do is just attack this and do this and do that and do that. But the realities of court is it's just not that cut and dry. It's just not that cut and dry. And for those who's been around court for years, you understand how court's very nuancey. A lot of new people, and you only your first dealings with court is credit card debts and third debt buys. Yeah, that's getting your feet wet. But the longer you hang around the hot dog stand, you're going to understand exactly what I'm talking about. 100%. All right, y'all. It's been real. It's been Holyfield. And yes, we are going to land the deal.
You're rocking with the DJ that keeps the hits coming.
Wait up, run it up, run it up. I'm in the kitchen cooking up something new, yeah. She's singing along to our favorite tune, wow. Enjoying the breeze from Toronto. They admire my watch.
You're rocking with the best.
Like you had something to share. What's up? I'm back in this game, now you're waiting on the bench. I thought so. Okay. He's back in this place like he had left something behind. Celebration for tonight. I'm feeling ready for the night. Confidence high, we making moments to remember, and leaving behind the worries, moving forward, favor. Got a plan but no rush, just taking it slower and better. Embracing the job with friend and enjoying the ride. My
You're rocking with the DJ that keeps the hits coming.
Negativity, let's lift up. This energy's electric, bringing us together. Feeling alive and fulfilled. Shawty saying that I am the one. Who does she think she's talking to? She wants someone who brings unity.
Breaking off another hot explosive mix.
That's Culture Empire. Numbers don't lie, they testify. Books, open case law. Reading every line like a judge on the last call. Turn credit acceptance to a conquest. Took a contract apart.
We're about to take it back.
Gotcha, bitch. Thomas in the lab, books open, case law. Reading every
You're
line like a judge on
rocking
the
with
last
the
call.
best.
Turn credit acceptance to a conquest. Took a contract apart. Made him confess. Consumer finance, that's chess, not checkers. Built a blueprint, now we training whole sectors. From the payment plans to the charge-off sheets. He can map out the money like Manhattan streets. Understand risk.
You're rocking with the best.
Break a deal down, show the hidden obligation. He don't chase clout, he chases precision. Every decimal in place like a surgeon's incision. Supreme elite, we got receipts.
You're rocking with the DJ that keeps the hits coming.
We see a breach, Thomas turn pressure and the long-term wins. Dark in the hook, but the numbers still glow. Empire built slow, while the cash flow grows. Supreme elite, we got receipts. Every page proof that the squad still knows. Accounting on point, every entry aligned. From the pool to right down balance, never behind. He could trace every fee that they padded in the margin. Pull a spreadsheet up, whole case starts talking. Securitization, he can see through the stack. Notes, transfers, trust. Bring the paper trail back. They bundle up the debt, try to bury it deep. Thomas read the prospectus like a wolf in the sheep. Litigation mind, he'll cross X and pivot. Turn a weak clause to a weapon in a minute. From discovery to trial, strategy tight, knows which doc makes the judge sit upright. New culture empire, that's
You're rocking with the best.
Teams how the system pretends. Supreme elite forming up under his lead, he plant. Real knowledge like a long-term seed. Supreme elite, we got receipts. Stamped in the ledgers and the court transcripts. Supreme elite, we got receipts. Every page proof that the squad still knows, yeah.
Every claim, every fee, every clause, every plea. If the math don't match,
Gotcha, bitch.
Then the truth ain't free.
He could track that trail through the ledgers and lies. Pull facts from the fog, put a win in your light. Supreme elite, they study while the loud ones tweet in the dark. Thomas still reading receipts.
You're rocking with the best.
Supreme elite. Supreme elite.
You're rocking with the best. You're rocking with the best.